Hello, a very good morning to you. This is The Big Issue. You are welcome. It's your platform for incisive analysis and riveting conversation. I am Selom Adunu. This morning, the show, as always, is live and interactive. You can join the discussion via our WhatsApp line 020-444-7033 or 0549-986-996. We are live on 97.3 City FM. We are also live on our socials. Indeed, today is a big day for the This is Ghana exhibition, and so it's happening live at the Sutherland Children's Park. It's a good time to pass by with the family to see what innovations Ghanaian business people or entrepreneurs have put together to encourage our economic turnaround as a people. So, of course, we are here. We will go there after today's or this morning's program, but we'll entreat all of you to pass through the Sutherland Children's Park and have a good time for yourself. So our plate is full this morning. In the course of the week, the president removed the Chief Justice, Gertrude Saki Torkonoo. The question is this due process or political witch hunt? A number of things have been said about the Article 146 proceedings or processes. People think that the process in this particular case was not fair to Justice Torkonoo. We will look at all of that and see what becomes of Article 146, especially now that the Professor H.K. Prempeh's Committee on Constitutional Review is working and about to submit its reports to the President. Are there any particular things you want to see them do in respect of Article 146? There are three arms of government, and it does appear that the two, that is the legislature and the executive, have very stringent and very difficult ways of removing their heads. However, in the case of the judiciary, it just takes a petition to kickstart the process, and it could be anybody's game. Let me know what you think about that. Of course, we will delve into some of the key issues that the committee set up by the president to investigate the Chief Justice, some of the things they said they based their decision on. There were 3 petitions submitted to the president in respect of this and all. Only one is being concluded, and the decision has been based on this particular one, that is Daniel Ofori's petition. We will examine all of those. Why didn't the committee even wait to finish the 3 before coming out with a verdict? Or did it mean that because they found enough grounds to remove the lady, it then becomes moot going into the other 2? We will discuss all of that. Also, we will look at the issue about sale of state lands. If you recall, prior to the 2024 election, there was a lot of talk about state lands being misappropriated in many cases, people buying state land for pittance, and people think that generally wasn't fair. They called it land grabbing. The president, soon after taking office, placed a ban on the sale of state lands. Now, that ban has been lifted essentially. So what does that mean? Does it mean that anybody can now go and buy state land, no matter where it's located? Are there particular things we need to know about this? We will discuss that as well and see whether there are some exceptions to it. And why should people even want to buy state lands? Shouldn't we reserve state lands for the use of the state for critical amenities? We'll discuss all of that this morning. I'll take a short break. I will return, provide some updates, introduce my guests, and then we'll get a discussion underway. I am Selom Adunu, live and interactive show. Join us, and we'll read your comments out to the rest of the world. We'll be right. You're welcome back. This is The Big Issue, 97.3 City FM. We are live also on our socials. This is ChannelOne Television. My name is Selom Adunu. 2 key issues we have on the table. The removal of the Chief Justice. We're asking whether this is due process or it's just political witch hunt. Many have accused the NDC of having promised to purge the judiciary if they want power. They want power, and it does appear to those people that that is what exactly is being carried out. But people say no, the process was followed. Petitions were filed or submitted, and that kick-started the process. The process had to conclude, and so we saw a conclusion of that process this week. The Chief Justice, Gertrude Torkonoo, no more is the head of the judiciary. One of the things that also came up regarded the fact that she was a member of the Supreme Court bench, and the warrant that revoked her appointment or nomination or her role as head of the judiciary also mentioned the fact that she also ceased to be a justice of the Supreme Court. That has generated some controversy and discussion. We'll look at that as well. We'll also, in the second part of the show, deal with the matter of the president lifting the ban on the sale of state lands. It was a big matter prior to the election. Now the president is satisfied with the processes he's put in place, we understand, and he's lifting this ban. What goes into it? Can just anybody acquire state land? What are the modalities? Are there any exceptions to it at all? We will discuss all of that. Now, let me provide you some updates. The President, John Dramani Mahama, has, in accordance with Article 146 of the Constitution, removed Chief Justice Gertrude Saki Torkonoo from office with immediate effect. The decision follows a receipt of the report of the Article 146 committee set up to investigate a petition submitted by a number of persons, but in this case specifically Mr. Daniel Ofori. ChannelOne News' Jude Duncan has been following the removal process, and he filed this report.
Justice Gertrude Araba Isaba Torkonoo, Ghana's former Chief Justice, was born on September 11, 1962, in Cape Coast in the Central Region. She attended Wesley Girls High School and Achimota School before pursuing a law degree at the University of Ghana and qualifying at the Ghana School of Law in 1986. She later studied international law at Erasmus University in the Netherlands and earned an LLM in intellectual property law from the Golden State University in the USA. Her judicial career began in 2004 as a High Court judge. She was elevated to the Court of Appeal in 2012. She was appointed to the Supreme Court in December 2019 and sworn in as Chief Justice on June 12, 2023 by President Nana Addo Dankwa Akufo-Addo, succeeding Justice Kwesi Enin-Yeboah. In March this year, President John Mahama received 3 petitions, which would later rise to 5, seeking her removal under Article 146 of the 1992 Constitution. A prima facie case was established, leading to her suspension and the setting up of a 5-member committee of inquiry to investigate the matter. The minority in Parliament, together with a coalition of political parties, staged a Save Our Judiciary demonstration to protest the suspension process. In May 2025, multiple lawsuits were filed challenging her suspension. Counsel for one of the petitioners, Ibrahim Anyas Mohammed, expressed frustration with the process, calling for a review of the removal procedure.
The decision by the President of Ghana clearly prejudices and impedes the determination of the matter in court. As you know, I am lawyer for the plaintiff in the case of Theodore Atakorte, a plaintiff who seeks to challenge the removal process and seeks a clarity from the Supreme Court as regards the processes and procedures that underline the Article 146 Clause 6 procedure. So we were in court to not only to challenge the procedure, but to also ask for further clarification as to the propriety of the process itself. Now, this decision by the President not only overreaches the ultimate decision of the apex court, it is also a usurpation of the judicial power, and it is not in the best. We are not in the best position to speak about it for now. But I can say that my client is very disappointed by such a decision by the President.
In June, the suspended Chief Justice held a press conference to address the removal process. She alleged intimidation by the committee, criticized the petitioner Daniel Ofori, and questioned Justice Gabriel Poaman's suitability to chair the committee of inquiry.
How can Justice Poaman, who gave judgment in favor of Daniel Ofori as part of a panel of Supreme Court, and whose opinion I dissented with, which has made me a target of Mr. Ofori's anger, preside over processes to remove me as Chief Justice because of complaints that Mr. Ofori has? I have already protested that there is a conflict of interest for Justice Poaman to chair the committee trying me or hearing me on Daniel Ofori's petitions. What Mr. Ofori's allegations seem to suggest is that a court user can attack the Chief Justice and ask for the removal of the Chief Justice if the Chief Justice does not agree with his case while sitting as a judge, or if his preferred judge is unable to hear his case. And now the judge who supports his case gets to preside over the removal process. Apart from these two allegations, Mr. Ofori has no interest, no personal interest in all the other allegations he's making. And he should not have been allowed to conduct a litigation against me under the disguise of an Article 146 proceeding.
In July, the suspended Chief Justice challenged the process in court and later petitioned ECOWAS court alleging violations of her rights in connection with the removal process. Earlier on Monday, Supreme Court Justice Gabriel Scott Poaman, chair of the Article 146 Committee of Inquiry, formally presented the committee's recommendation on the first petitioner to the President, John Dramani Mahama. Reports on the remaining petitions are yet to be submitted. Hours later, the government announced her removal from office. According to the government spokesperson Felix Kwachi Ofosu, the committee found that grounds of stated misbehavior under Article 146 had been established, leading to the recommendation for her dismissal. Justice Gertrude Torkonoo is credited with spearheading key judicial reforms, including the automation of Ghana's court through the e-Justice project and the strengthening of commercial justice delivery nationwide.
All right, so that was a report by Jude Duncan on the whole process. My guest for today's show, Paul Adomotri, journalist, host of Good Evening Ghana, even though this is in the morning. Beatrice Anamfio, presidential staffer. John Darkon, of course, MP for Swami. Andrew Apiakubi, spokesperson for Movement of Change, also a private legal practitioner. And of course, Franklin Kujo, President Imani Africa. Gentlemen and lady, welcome to the program.
Thank you.
Paul, let me start with you, really. I've seen you discuss a lot of these matters, etc. But how big a precedent is the removal of Justice Torkonoo as Chief Justice of the Republic of Ghana?
Well, thank you very much. To the extent that's the first time it's happened under the Fourth Republic, it is a significant precedent. But I think it's unfortunate, whichever way you look at it. If the Chief Justice was guilty of the offense charge, it's unfortunate. If she was not guilty and the process was unfair to her, it's even more unfortunate. But as a country with a growing democracy, the issues about conflict in opinion or conflict in philosophy between the three arms of government is really bound to happen. And so in America, it has happened so many times. It continues to happen. But the way in which these things are resolved is to use most of the processes provided in the law, but hardly ever to touch that sacred impeachment process. And the history of our own country is clear with that. The first president of Ghana, Dr. Kwame Nkrumah, had occasion to actually dismiss Chief Justice Seyaku Kosa on account of a ruling that the court had given. And it occasioned a disagreement between the president in terms of his view of the matter and the courts that heard it. This had been an attempt, a bomb thrown at the president, and you can understand the president will be quite emotional about that. A bomb thrown at the president's investigations suggested to him that his foreign minister, the Honorable Akwaje, and his information minister, Adama Fio, were both involved in the plot. And so that would look like a big betrayal. So the president must have been quite emotional about that. The matter went to court, and on account of the evidence before the court, the decision was made by Seyaku Kosa that these two gentlemen were not guilty of the offense. However, others were guilty. The other people were charged. The president was infuriated by that and decided that he will sack, just dismiss. There was no process at the time. Just dismiss the Chief Justice, which he did. And in that constitution of 1960, there were limited powers granted to the president of Ghana to participate in legislation, to make laws. So the Osajifo decided that he will access that process and then actually went to pass a bill in Parliament, which became law, permitting the president to be able to remove the Chief Justice and justices of the Superior Court of Judicature. In pursuit of this law, the president proceeded to remove some other judges in subsequent situations. So it was clear that the president of Ghana could do so. Many people didn't like it, and it affected the social fiber and the way the democracy was working at the time. Anyway, good or bad, the coup came. So if you look at the 1969 Constitution, which is the constitution that came after the 1960 Constitution, there was actually no provision for and there was a provision that said that no one can remove a judge of justice of the Superior Court of Judicature or the Chief Justice and all of that. It was very, very tight in 69 Constitution. The reason was that they were trying to correct this horrendous situation of the first one. Now, in that, in the short operation of that Constitution, there was major disagreement between the executive and the judiciary. The president and the prime minister who carried executive power at the time and his people had decided to sack some top civil servants because, as it were, they were resetting. In those days, they call it purging the system, but they were resetting. And the reset took them to remove 658 civil servants. One of them decided that, look, I'm going to challenge this.
That's Salah.
Salah went to court and challenged it, and it was a big issue. The Supreme Court ruled. In fact, there was a major preliminary application about bias here and there, and it was resolved. And then the big ruling came, and the Supreme Court held that the Prime Minister does not have the power to do so and so. It's offended the Prime Minister, and that always happens. But there should be no discussion of, I will remove you when I get you, or it should be a discussion that uses the other remedies, if you like, rather than this very sacred removal. So then the government, legislative and the judiciary is bound to happen, or the judiciary and the legislature. But the way constitutions have operated across the world and the way in which we hold these constitutions, hardly do we talk about we are going to remove somebody. In 1979, the situation was similar. There was a Chief Justice called Justice F.Y. Apalu. But there was a coup d'etat between 69 and 79. And during the coup d'etat, the soldiers, when they come to power, they banish the executive and then they terminate parliament, but they leave the judiciary to work, except that they leave the judiciary to end at the Court of Appeal, often no Supreme Court. So this was the situation in the 79, the interregnum between Champon and Akufu and all that, and then the elections of 79. So Apalu was Chief Justice. The Constitution of 79 said that for the superior judges of the Superior Court of Judicature, any judge who was already a judge, High Court, Court of Appeal, Supreme Court, no Supreme Court, so High Court, Court of Appeal, any judge who was already a judge before the coming into force of the Constitution will remain a judge as if appointed under the Constitution. This was the provision that was in contention in the court. Now, the CPP guys had won the election. They felt that F.Y. Apalu was the opposite. He was UP, and they were not quite sure about working with him. So they thought about getting him out. There was a provision in the 1979 Constitution, Article 124, which is the same as Article 146. So they could have used that process. They knew they could have used that process, available to them. But because that process is such that you don't really often touch it, you leave it until it is very, very, very critical to do so. That's why the provision is there. It's not a provision that you tinker with every 5 years or every 10 years. Anyway, so they saw that Article 124 was there. The provision was there, but they didn't want to use it. So what did they do? They decided to find a way in which they can manipulate the transitional provisions and the new constitution. So where the transitional provision says that anybody who is a judge will remain a judge, and Justice Apalu was the Chief Justice, but part of the Court of Appeal because there was no Supreme Court. And the judges who were elevated to the Supreme Court were elevated as if they had been appointed under the Constitution. What did they do? They nominated Justice Apalu for the position of Chief Justice. He was already Chief Justice. He was then nominated again by the President. And the nomination sent to Parliament for vetting. When Justice Apalu appeared at the vetting, he told the committee that he doesn't think he should be here because he's already Chief Justice. under the transitional provisions, he remains Chief Justice, and therefore he's Chief Justice and part of the Supreme Court automatically. The appointment committee said, well, the president has asked you to come. It's up to you. Do you want to do the interview or not? He said, I'll do it. So they took him through the vetting process. The verdict came and he had failed the vetting. This is the way they tried to go about it, because they wanted him out. They knew that they had Article 124. So they said, Apalu has failed the vetting. Apalu then decided that, no, I will take an application before the Supreme Court and ventilate this matter. Eventually, he went to the Supreme Court and he won. And he remained the Chief Justice of the Republic. But this is what the CPP guys tried to do. But they knew that they had Article 124 in their constitution. They could have started the constitution, bring somebody to file an application, refer it to a committee, go under in camera and get him out. They knew they could do that, but they didn't want to do that. Then came the...
But why, in your view, do you think they didn't want to do that?
That's the point I'm making, that these articles
you really
and provisions...
touched But in our situation, we've touched this particular provision a number of times. Peter Witaderi and all of those... Charlotte Osei,
I'm coming to that.
We've touched it.
Yes.
So.
Yes. So you see, when I say touch it, I mean
removal
something that looks like orchestrated by politics. That's really what I'm saying. If an individual, in the case of the dairy one, it's a different matter. It's not executive or another arm of government, or it doesn't seem that it's politically motivated. It's a completely different matter. On such occasions, you may be able to do it. But I'm also talking about touching it in respect of the Chief Justice, not as other Supreme Court judges. The Chief Justice, that one, that's the big one I'm talking about. So that was 79. Then we came to 1992 Constitution, and we imported the provisions of Article 124 into the 1992 Constitution, which is
now as 146.
As 146. The first major brush between the executive and the judiciary under 1992 was the ruling in 31st. It was a ruling that rubbed Mr. Rawlings on the very wrong side. And it was all said that one judge, a former Attorney General, NYB Adade, was responsible for what was termed the coup d'etat at the Supreme Court, because he led the majority opinion of 5 judges. And it was said that it was he who convinced from Benjamin, who in the afternoon during the conference was still in balance. He was looking left or right. And it was Adade who convinced from Benjamin to become part of the decision, as they put it, against Rawlings. In his sessional address to Parliament in 1994, Flight Lieutenant Rawlings found occasion in the sessional address to berate the judges and almost give a warning. And that is the extent to which he was upset with the ruling. Article 146 was there. They could have occasioned an Article 146 petition against NYB Adade, against other judges, and remove them from the court. They could have done that. But because it is rarely touched, all Mr. Rawlings did was to speak about it in Parliament, in the sessional address. We have to be mindful of the fact, as I'm making the point, that there could be an error of judgment on the part of the Supreme Court. That's very possible. They are not infallible. So there could always be an error of judgment on the Supreme Court. In fact, there are those jurists who feel that Nkrumah's decision to remove Kosa was genuine, because if you look at the accounts of what happened and the interactions between some of the accused persons and those who were convicted, you really can't find why you convict this and not convict the other. There are some jurists who feel that. So the Supreme Court may have been wrong in 31st. It's entirely possible. The Supreme Court may have been wrong in decision A or decision B. That happens. It's happened all the time. The law is replete with these things where decisions are overturned. But even if they are wrong, the way to manage it is not to rush to the Constitution and find Article 146 and take them out. The problem that, the case goes on from Rawlings. You know how Kufuor was completely outraged about the Chikata decision. President Kufuor had come into office in 2001. The NPP had campaigned on corruption in a big way. The NPP had wanted to show Ghanaians that they were serious about corruption. So something like oral, what they did was that we are setting up special courts. It will catch all the thieves and deal with them. It is called Fast Track High Court. It's very fast. This one, they won't go there and go and waste our time. It's very similar to oral. So it was a campaign thing. So they came into office and they needed to respond to their base. So they set up Fast Track High Court. It was held all over the place. And those days when, if you live in Adenta, there was a big washing bay there. He puts his big there, Fast Track washing bay. and everybody was talking about it because the word fast track became, something sexy that the youth was talking about. Then Mr. Chikata, one of the arch rivals of the NPP administration at the time, is to be prosecuted. The prosecution is laid before the fast track high courts. There's political bragging that, okay, now we have Chikata, he'll go into the fast track high court, it will be fast, blah, blah, blah. Then Mr. Chikata goes to the court to challenge the fast track itself. It's like somebody take an application to court today to challenge oral, and people talked about it. And then the court rules in favor of Mr. Chikata. The Supreme Court, sitting as 9 judges, 5-4 decision in favor of Chikata, to, as it were, outlaw the fast track high court. Huge decision, big one. Mr. Kufuor was concerned. The MPP administration, the Attorney General, they were very concerned. They could have said, oh, is that how this Supreme Court is going to behave? Article 146. Let's go and deal with it.
But there should have been grounds for it. These were judicial decisions.
But that's the point I'm making, that a lot of the times, when the Article 146 comes, and that's why I have Sal here, when it's political, it is not about what has been written. It is a decision that has been taken to remove this person or that person, and then they find it. When it's political, it's not. They will not come and write that you made a decision in this case. No.
So they'll find a reason.
They always find a reason. So when you give a ruling like that, that hurts the politics, or that makes people upset in a political sense. Clearly, in a political sense, this fast track ruling was about politics. The decisions that Justice Torkonoo made in the
vacation
of
seats.
Yes, the vacation of seats matter. It's robbed the NDC on the very wrong side, in a very political way. Since Justice Torkonoo has been removed, there's been important people on social media who have celebrated her removal as a result of SAL. The Santrofi, Akwafu, Lolobi, and Likwe situation. And I've been looking at that situation critically. I don't find where Justice Torkonoo is being held responsible.
So you hold it there.
Yes.
Let me go around the table and I'll come back.
Perfect.
Welcome. John Dakun, welcome again. Counsel for the Minority and MP for Swami. Very big seat, and I think you're dealing with it quite well. You issued a statement shortly after the news of the removal of the Chief Justice, and you had some very strong words for the system. You call this, a flagrant assault on the judiciary by the head of the executive branch of government, which you said brings into sharp focus the destruction of the state institutions by this administration. Ghana, you said, joins the enviable group of nations.
Unenviable.
The unenviable group of nations like Pakistan, Bangladesh, Sri Lanka, etc., who have removed their chief justices. And you said other things about Gangster Town and all of that. But why do you pin this decision on the executive when indeed private persons or private person in the specific matter, Daniel Ofori, petitioned the president, kick-started a process, and got it to the end?
Thank you, and good morning to your viewers. My brother, I think that is what we are failing to see. We are failing to see the actual thing that is happening to our institution. We are trying to just pin it on some legal theories. The actual thing happening to the judiciary is the political game being played by the NDC. I must say they have played it well. And I issued a statement because of what we all know in this country, that what kick-started this process is not Daniel Ofori's petition. What kick-started this process was the president's desire to remove the Chief Justice. And he has said this, and I think it's well known. I think everybody is aware.
Remove the Chief Justice?
Of course. So from his meeting with the NDC lawyers, which was well broadcast the whole country.
But did he say he removed the Chief Justice?
I'm coming. He has said that he was going to reset the judiciary. And so do you think that he will say, I'm going to remove the Chief Justice when he knows very well that he was in a very serious position? At the time, he was the presidential candidate for the NDC. So he said that we were going to reset the judiciary. Now, when he finished, all the conversation that followed, they were just re-echoing his view.
The Bible said you reset the judiciary.
And I'm coming.
It could mean by policy. It could mean a lot of things, not necessarily removing.
So at least now we are seeing clearly what he meant, and it was re-echoed by no other person than his chairman Chairman Sedun Ketia said it clearly. I mean, you have the videos there.
That they will remove the
that the chief justice, yes, must go. In fact, even earlier this year, he mentioned that, and he followed that with the statement that the Electoral Commission chair must also go. I mean, this video is out there for everybody to see. He has said that the Chief Justice must go, the chair of the Electoral Commission must go. In fact, at the time they were making these statements, the petitions that, as we know, hadn't been filed. So what formed the basis for those claims?
No, but
they had always
known Ketia or anybody have the power to remove the CJ.
Oh, come on.
I mean, they could say things, but the process will have to be gone through. The process is provided for in the Constitution 146. So in fact, it's not the first time that a petition, for example, was submitted or filed against Torkonoo. Professor Azar, unless of course you want to say Professor Azar is pro-NDC, but I don't think so.
Yeah,
he submitted a petition. Only that it was dismissed by Akufo-Addo.
Yes, I'm not going to look at all those ones.
But the point I'm making is it wasn't the first time a petition was submitted against Torkonoo.
Okay, good point. The point is that Sedun Ketia is no mean a person. In fact, he attends cabinet meetings, even though that is not what the Constitution says. He's always in their cabinet meetings. Oh yeah, of course. Unless my sister here would deny that.
But so, Beatrice is not a cabinet minister.
No, but she knows those who attend cabinet meetings. So we are saying that when you look at what happened, okay, it was just a political attempt by the NDC, and they played it well. From the spokesperson to the NDC, Mr. Fagman, they had always been, though these guys have always been on the radio advocating for the removal of the Chief Justice. In fact, even before they won power. And at the time they were saying these things, they had no basis, okay? They had always insisted that the Chief Justice must be removed. And what was their reason? Their reason was that because Charlotte Osei had been removed, when they come, they were going to make sure that they remove the Electoral Commission chair. And the only way they can do that, in their view, is remove the Chief Justice, install a Chief Justice of their choice, who would then make a prima facie determination against the Electoral Commission chair. And then the Electoral Commission chair will be removed. We are in this country. I mean, this thing is just playing right in front of us. You will know that sooner than later, a petition for the removal of the chair of the Electoral Commission will also come up. And they would, well, for us, it's just a petition that came and the Chief Justice made the prima facie determination and then we went through the process and the person has been removed. Let us not bury our heads in the sand like ostrich and pretend that what is going on here is some constitutional procedure, because it is not. What is happening is pure politics. And I've made this point before, even on this show. If you look at the constitution of the Council of State, if you look at even the persons appointed by the president, they will come and tell us that, the president is mandated by law to appoint, how many Supreme Court judges? 2 Supreme Court judges, and then 3 other persons. Look, who doesn't know Dom Levo? Who doesn't know what it stands for? Is it not part of the oral team, those who were going around saying that they were going to arrest NPP people? So clearly, these are people
I didn't hear Dom Levo say they were going to arrest.
But Dom Levo, Martin Pebu, and Okujeto Ablakwa, they work together. If we work with Okujeto Ablakwa and Martin Pebu, who are you?
No, who are you asking for? You're a Ghanaian. I mean, the former Auditor General. I mean,
so I mean, clearly, the president could have found, in my view, maybe. I don't even know whether they're neutrals in this country anymore. A proper neutral person to sit on, because all these are political, persons who walk around as if
could not think independently.
Who walk around as if they are neutrals.
Not think independently.
Who walk around as if they are
analyze
neutrals.
issues for what they
because
are.
they are not. They are not neutrals. They all have their.
They could not think objectively about issues.
They all have their political inclinations, and they work for the president who appointed them. And so look at the constitution of
the committee.
The committee, look at the constitution of the
and the committee had Justice Poorman, had Justice Adibu Asiedu, who was appointed by former President
Justice Poorman,
former President Akufo-Addo. In fact, Akufo-Addo promoted, under Akufo-Addo's regime, he was promoted from the High Court to the Court of Appeal, then to the Supreme Court.
So Justice Poorman...
He was one of the judges that CJ Torkonoo empaneled to hear the matter that came before the Supreme Court those initial times.
Yes, so Justice Poorman himself, the CJ has had cause to complain about, his involvement, at the former CJ, had cause to complain about his involvement in the case. For me, the point I'm making is that if you look at what is happening or what has happened to the
it was orchestrated and it played out as planned.
Exactly.
That's the point.
And they clothed it with this constitutional provision. And you know my views on this. It's come here before and we've discussed it. For me, it is nothing more than the policies of NDC being played. From the General Secretary all the way to their members, they had always insisted that the Chief Justice must go at all costs and then install a new one who will now
they
make
found a provision.
Yes, they found a provision in the
But you can't say in terms of
Constitution
the provision that anything was breached. You cannot say that, can you?
It shouldn't have even started in the first place. If the president wanted to do right by Ghanaians, this thing would have been dismissed from day one. All they wanted to do is to remove the Chief Justice, and they've succeeded. Their point is that they want to install their Chief Justice, who will now make a prima facie determination. Then they will remove the chair of the Electoral Commission.
Well.
And I think that the idea that the president wants to control all the levels of government is very dangerous, and Ghanaians should be worried. We need the purpose of our constitution.
You allege that as well.
Yes,
but is there any evidence to back that he wants to control all levels of government? I mean, of course, the parliament.
But that's what it is.
I mean, that was the decision of the people of Ghana, so they gave him an overwhelming majority. He is for the executive, obviously.
And then he wants this as well.
Well, we don't know that.
It's never happened that within first 4 months of an administration, 7 members of the Supreme Court, are nominated. It's never happened. And what you accuse the Chief Justice for, you said that she had at one point recommended for increase of the numbers at the Supreme Court. Complain that she should never have done that.
But that complaint was procedural.
You come to power, the first thing you do.
No, but the president was not procedurally wrong.
My brother. So the woman was talking about the numbers, right? They berated her for that. They berated her because she had gone ahead to suggest names to the president. Yes,
which shouldn't be.
And that is a stated misbehavior that should warrant a removal of a Chief Justice. If this is not politics, what else is politics? How do you tell me that? Let me make my last point. How do you tell me that the head of an administration who has administrative powers cannot transfer somebody in the administration, and that should warrant a removal? If this is not politics, what else is?
But yes, you can transfer, but the transfer must be fair.
How? How?
The transfer must be fair, and it should not be arbitrary. So they quoted 296.
Yes, and you are telling me that a Chief Justice who is the head of the administrative head of the judiciary cannot transfer somebody, and if the transfers,
it's not about the transfer. It's about the nature of the transfer.
But look at the head of the judiciary is the head of the third arm of government, 3 arms of government. So her position is a superior position that
puts her above the law.
No, but what should warrant a remover should not be something as trivial as this. Then you transfer somebody from one. And the person is not even dismissed within the administration, transfer from position A to position B. You are saying that discretion was not exercised properly, and so it should warrant a removal. That is why I'm telling you that. If you look at the totality of the case, the reasons they assigned for a removal, it shows nothing but politics.
Very well. So what's the thinking, the feeling, around the corridors of power? I mean, Torkonoo has been removed. What's the feeling? What are people talking about?
Good morning to our viewers and our listeners, and I'm happy to be here. It's been a long time. I don't think that for us in government there is any feeling or anything to talk about. I think we are moving on and everything is running perfectly. But it's important to also let viewers know from government's perspective that this removal was not political in any way. In fact, I happen to work at the presidency, and I can tell you that on assumption of power, if we had any preoccupation and major issues that we wanted to tackle, removal of Chief Justice was not one of the issues that government was concerned with. And so the point has to be made that this is not something that was on the agenda for President Mahama. for which reason someone can say that it is politically motivated. But it is also instructive to make the point that people cannot merely say that this was politically motivated without some form of evidence to show that there is a basis for making that statement. I've listened to, until today, he wasn't my very good friend, but now he's becoming my very good friend. My very good friend, Paul Adomotri. I've listened to Honorable John Darko, who happens to have a very big position, counsel to the entire minority caucus. Is that the case?
Yes.
And I want to put on record that contrary to the assertion of Paul Adomotri, this is not some philosophical difference between the judiciary and the executive. Contrary to Paul Adomotri's assertion again, it is not a matter where the Apex Court has delivered a number of decisions and government disagrees with, those decisions delivered. And so, pursuant to the disagreement, then some positive acts will be taken to remove the head of the judiciary. It is also not something which is orchestrated. And I want people to make time and listen to me. The petitioner, Daniel Ofori, is not a new person to the removed Chief Justice. The petitioner, Daniel Ofori, is an avid litigant. He's a businessman, by far one of the richest businessmen we have in Ghana. This man goes to court on a number of issues. He has issues with Madame Torkonoo, even as a High Court judge. And Madame Torkonoo is no mean a legal practitioner, and for that matter, a judge who has practiced for over 22 years. And so it cannot be that the NDC came to power and within a space of 4 months, we had it on our agenda to remove the Chief Justice. Let me take you through a little bit of history. Maybe that history may not be known to my co-panelists, and so they may come to that conclusion. The checkered history is that Daniel Ofori had a case against EcoBank, and they had gone through the judicial processes, and Daniel Ofori had, won the case from the High Court through to the Supreme Court and even on review. And along the line, there were a number of applications which lawyers we do and we file. In 2 of those applications, suit number J8/114/2020 and suit number J7/13/2020, the Chief Justice then, as part of the panel, had ruled against Daniel Ofori. Among other things, Daniel Ofori then said that given the checkered history of this woman and given some statements she had made in other cases against me, she had this likelihood to exhibit bias against me if I brought any case again in the matter of EcoBank. And so, Supreme Court, please ask your colleague to step aside. The court granted this application that indeed, Justice Torkonoo was likely to be very biased against Mr. Daniel Ofori, and for that matter, she ought to step aside. That is very instructive because even as legal practitioners, we know that the test for asking a judge to step aside, especially when the person is a member of a panel and not a sole judge, is a very high or a tall thing that you need to mount. And so for the man to be successful, it should tell you the evidence that I believe was presented before the court. That was not even the case. And at the time, the court asked them
But it could have been that Torkonoo herself felt that there was no need in litigating.
No, it couldn't have been. Daniel Ofori took an application and the court granted that application. So she didn't recuse herself. It was the court that ordered that. But tell them this wouldn't have been an issue because judges every time are asked to recuse themselves. I don't expect that if my friend is a judge and I have a matter, someone should not raise the issue. But this is what happened. After the court had asked Justice Gertrude Torkonoo to step aside, she then became a Chief Justice, because at the time she was being asked to step aside, she was not a Chief Justice then. While she was a Chief Justice, there were 2 cases already pending in respect of the same matter that the court had asked her to step aside because there was a likelihood of bias. These courts were pending before first the Commercial Court 7 and then General Jurisdiction 6. First, EcoBank had, issued a writ to set aside the judgment that Mr. Daniel Ofori had obtained. And then second, there was an execution process which Mr. Daniel Ofori commenced. While these 2 cases were pending, Justice Torkonoo then became a Chief Justice. You know the first thing she did? She transferred both cases from the judges without any cause. First, from General Jurisdiction 6 to General Jurisdiction 8.
She explained that the judge in question had some emergency or family matter that was going to take him out of the country for a long time.
Yes.
That was unknown to Daniel Ofori.
One of the reasons we have, and one of the challenges we even have as private legal practitioners, is the delay which is occasioned by our cases. There was nothing emergency about that.
No, said the judge applied that he had to leave the country. Of course, he didn't need to tell Daniel Ofori that.
Yes.
So, as CJ, she granted
yes, I think
and transferred the case to other people.
In fact, she had the administrative right to transfer cases, which she exercised. And then she also transferred the Commercial Court 7-1 to, and in the Commercial Court 7 case, there was nothing that was wrong with the judge. Because I have appeared before the judge in Commercial Court 7 several times. She's such a good judge. There was no excuse of her going. So that's the second leg, which defeats the intention. But you see, with that,
her defense. Sorry, Martin. Her defense for that or explanation was that once the 2 cases were related, the common practice is that you put the 2 together before the same judge. And that was
they were different. One was on execution, and one was actually on
in respect
EcoBank.
of
So one was in the first one in Commercial General Jurisdiction 6. EcoBank was the plaintiff, and the one in Commercial Court 7, it was on execution. Those 2 cases were not so related, but assuming she even took the view that they were related, we ought to oblige her. That is her administrative right. I don't think she did anything wrong by exercising her administrative right. The optics may not have been good, especially because of the decision against her to recuse herself. But I don't think she did anything wrong, even with that. That is her right. But I am making this point to tell you that there is a checkered history between Daniel Ofori and the removed Chief Justice. Among other grounds, Daniel Ofori was aggrieved, and so a petition was brought against the Chief Justice. Nobody can tell me that by the account I have given, which I do not even want to debate the merits or otherwise, whether she did something wrong or right, but that was the genesis of the petition against her. So nobody can make a point that the petition for her removal was orchestrated, because some of these things date as far back as 2018, 2020, when the NDC did not even know that the removed Chief Justice had some ongoing friction with Mr. Daniel Ofori. So that point has to be made. I now come to the part about, and many people have made this argument, that although there may have been some misconduct occasioned, it shouldn't have been such that it would lead to the removal of the Chief Justice.
They were not grave enough.
I think that as a nation, we ought to agree on what we want. Do we want that wrongs should be done, and every time when wrongs are done, we find a scale and attach some weight to the wrong? Or as a nation, we are coming to a point where we are discussing whether wrong is wrong and right is right. Salom, when a lawyer is defrauded, especially by false pretense, sometimes your probability of winning the case will be low. You know why? Because caveat emptor, we reasonably expect you that with the knowledge and requisite skill you have normally on legal due diligence, certain things should not happen to you. We apply the same standard to a Chief Justice. That as head of the judiciary, where your members or subordinates can misapply public funds, abuse office or powers of the office, you ought not to do that. The standard even is higher as a Chief Justice. And so let's not make the point and make it sound like, you know what, she may have misapplied the funds. She may have breached the laws on whether her spouse and child was entitled to the taxpayers' money. But let's ask, oh, it's just about $10,000 and $20,000. If we want to move away from that, so that I would be glad that we should be having and leading a jurisprudential argument where the offense of stealing will probably have, let's say, a cap, and say that where a person steals public funds below an amount of $20,000, that person ought not to be convicted, or that person ought not to be sanctioned. But where it is above $20,000, then the person ought to be sanctioned, because that is the invitation that is being made to the Ghanaian people.
So that's in respect of the per diem and the air ticket purchase.
Yes, yes.
But she says that per her terms, conditions of service as CJ, she is entitled or was entitled to travel with one person, only one person of her choice, for 2 vacations in a year. And on both occasions, she decided to go with her spouse, and then on another occasion with their daughter. So if the conditions of service allow her to do so, where then will lie the wrongdoing?
Okay, so this is where will lie the wrongdoing. The Supreme Court decisions are not merely things that they say. The words and the decisions of the Supreme Court, Salom, are in themselves law. For which reason the Constitution says that where you disobey the orders or the decisions of the Supreme Court, it will amount to high crime. So a Supreme Court judge cannot feign knowledge or ignorance of the law. And let me demonstrate to you. As far back as 2015, in the case of Nobokor versus Attorney General, cited as 2015 to 2016 Supreme Court of Ghana Law Report 114, that's at page 114. The Supreme Court was confronted with a similar matter, or whether or not the emoluments of Article 71 holders were such that it could be varied by anybody. The Supreme Court came to the decision that the emoluments determined to be enjoyed by Article 71 holders could only be altered by the precedent. So this is very instructive, and I want people to pay attention to this part so that nobody will say that there was any witch hunting or there was any wrong done. So this has been the decision in the what we call the Nobokor case popularly. So everybody knows that when it comes to what the judiciary is entitled to, or what Article 71 holders are entitled to, in the case of Parliament, it is the executive that sets up a committee to decide. In the case of the executive, another Parliament then also decide what they should be entitled to. Now, having made this point on the precedent set by Nobokor, the Chief Justice herself, Salom, in the cases of Dafia Mekbo and 2 others versus Attorney General, and Kwame Bafoboni Abronye versus Attorney General, the Supreme Court, and here, let me say that the Chief Justice herself, she was the presiding judge. I mean, she was the chairman of the panel, and she gave the unanimous decision of the Supreme Court. And I want to crave your indulgence to read what she said. This is what she said. It's long, but I'll just make it short for
the Abronye case.
In the Abronye case, she said, the tight, precise listing of the identified officers shows that the framers of the Constitution intended to leave no doubt about the persons and entities covered, and the fact that the non-listed persons cannot be included or roped into the model of emolument setting by simple extrapolative reasoning. These are the very words of Justice Torkonoo. And then she proceeds to hold that the Act of Parliament approving the recommendations to directly pay the spouses of the President and the Vice President's salaries that were benchmarked to the salaries of ministers and members of Parliament as part of the emolument of the President and Vice President is an act that is violently, she even uses the adjective, violently inconsistent with the clear directions, intentions, and purposes of Article 71. It contravenes the spirit and the letter of the Constitution. The meaning of what I have just read is that the justice herself, Justice Torkonoo, said that when it comes to your benefit and entitlement at Article 71 holder, you cannot, by some exploitative reasoning, expand the scope. And so anybody who expands the scope to cover here the spouses of the President and Vice President violently violates the clear provisions, not just the provisions, but the intentions and the spirit of Article 71. How did she then come to the conclusion that she, by some exploitative reasoning, to quote her words, could violently, again to quote her words, expand the scope of her entitlement as an Article 71
even
holder?
though it was explicitly provided for in her conditions
I
of
didn't
service?
give this judgment. Tell them, I didn't give this judgment. I'm not a Supreme Court judge. She sets the precedent. She laid down what the law should be. And the laws have been applied against her.
Very well.
What else will be my remedy? And Salam, let me respond.
And she made a point that even if that were the case, you know, the remedy was to surcharge her so she pays back.
No.
And we've seen that happen at the Public Accounts Committee, Auditor General's report, etc.
There would have been no need for an offense. Because every offense, whether the offense of killing, as long as I'm not killing, stealing, as long as no lives were lost, people could be given the opportunities to refund.
The element of intention is key. Unless, of course, we're able to establish that she intended to steal from the state in this manner.
Hello, unless somebody tells me the intent, that where the judge herself has set a parameter, that no Article 71 holder, you know, when we are ranking the heads of the arms of government, it is the President, and maybe sometimes the Vice President, not as head though, then the Speaker
and the Chief Justice.
The Chief Justice. Now you say that the two people who are part of an arm of government, the President, the Vice President, their spouses cannot be, Article 71 cannot extend to them. However, when it comes to my spouse, Article 71 can extend to me. But where I even violate the constitutional provision, I ought to be given remedy. How many people has she given the opportunity to remedy their wrongs? How many people?
But so I of course I need to move on. I need to come to
so I need to make the second point.
Okay.
I need to make the second point about Honorable John Darko saying that merely because the Chief Justice wrote to the President, it cannot be a ground for removal. I think that Honorable John Darko is a lawyer and cannot be forgiven if he makes that argument. A lay person can be forgiven, but he, as President or counsel to the entire minority caucus, is a very big post. He cannot be forgiven, and this is the reason. Article 1442 says that the other Supreme Court justices shall be appointed by the President, acting on the advice of the Judicial Council in consultation with the Council of State with the approval of Parliament. So it sets out the rule. But you know why it cannot just be a constitutional violation merely because the Chief Justice wrote to the President. This is why. The Chief Justice, on the 24th of June, 2024, at a meeting of the Judicial Council, made it expressly clear that indeed she was in communication with the executive. And it is based on that she wrote that letter to the president. I think she completely forgot herself. And these are the minutes of the Judicial Council meeting. Don't ask me where I got.
You have me.
Yes, because the principle is that.
That's very interesting.
Yes. So let's conclude from it.
I'll conclude and you respond. The principle is that, you know, as a lawyer, it matters not how you got it, even if you stole it. And this is the minutes. She further indicated that this is what the minutes captured, and I read verbatim.
No, but honestly, I don't think this should be allowed here because I mean we really don't know where this is coming from.
No, let's let's hear what
she said. That she further indicated that she had received a letter from the president considering the request of additional judges to the Supreme Court bench. She indicated that she received a letter from the Honorable Attorney General and Minister of Justice dated 20th June 2024, recommending persons for appointment to the Supreme Court. And this is where it even gets better. The Honorable Chief Justice informed members that she had convened a meeting because she had received a communication that due to the political atmosphere, His Excellency the President, June 2024, the President was Nana Addo, was anxious to send the proposed names as well as the earlier nominations submitted by Council to Parliament. And this, we are being told that where the President, and you know, the President has nominated a number of Supreme Court judges. And so they did not want to add this new nomination. And so the agreement was that the request should come from the Chief Justice, but that is in violation of the law. Are we saying that?
So I don't want to be the moderator, but I said this grounded in removal.
It was one of the grounds.
Very well. So now let's cross politics.
The Chief Justice's removal. It was based on the Daniel Ofori case.
Yes.
Only.
Yes.
So why are we discussing the other petitions?
No, it was in the Daniel Ofori case. So when you look at the letter, sent to her, signed by the secretary to the president,
Ofori matter.
That matter, yes.
I think that I have some information that I have to share with Honorable Beatrice. The transfer of the judges. I don't think what you said was actually correct in terms of why the matters were transferred. So the transfer.
I didn't say
the cases were with Justice Boansi. That particular case was not transferred. What happened was that she had family trouble, as the Chief Justice said in a press conference. I pulled it out, and had to travel suddenly to USA. Justice Miriku took over her court cases, all her cases, not just Daniel Ofori, as it is the practice. And then the other one, there was another case before Justice Lodo, which is the second Daniel Ofori case. That was transferred to Miriku after the lawyer for EcoBank. Both cases were Daniel Ofori versus EcoBank, Daniel Ofori versus EcoBank. Yes. So he applied to the court that the cases be united. Pursuant to Order 1, Rule 1-2 of the High Court Procedure Rule. So to suggest that this was some bias on the part of the Chief Justice is completely wrong.
I never said that. In fact,
you said that Daniel Ofori.
No, I think the point she was trying to make was that Daniel Ofori is very well known to the woman. And so, more or less, it couldn't have been
as if it was wrong.
I think what
she was doing was to establish a basis that Daniel Ofori couldn't have been influenced by the NDC to do so. In essence, Daniel Ofori was known to the lady or to the woman. And they had some history. She called it checkered history.
Yeah.
You know, so that's the point she was trying to establish.
And I made the
point. You're not saying that the Chief Justice did anything wrong in that.
No, she actually said that
she did anything wrong. That is her administrative right, and I will not fault her. But it was the basis for Daniel Ofori's petition.
So Beatrice,
it was in the petition. This was referenced. Yes, but that's the point. If this is referenced in the petition, this is nothing wrong. She's done nothing wrong. So she should not be found guilty on account of this one.
Yes, I'm not sure she was found on the.
But it is in the Daniel Ofori petition.
Yeah, but the Daniel Ofori petition had a number of allegations.
Yes.
And not all those allegations succeeded.
So which allegations did the committee find?
There were three.
There were three.
The per diem,
excluding
the per diem, the transfer, and there was another one in respect of the CJ's recommendation. Those were three.
The recommendation, the one you just read.
Yes, the recommendation. The transfer of one, Mr. Baden.
Yes.
And then
that's the staff of the judicial service.
And then the per diem bit.
So these were the three. So this one failed.
Yes, this one failed.
Because it didn't
feature it copiously.
No, I'm saying that this
Okay.
No,
I
so Paul,
get your point.
yeah. So the point was like,
My
You
point
are
is
trying to
that-
show the relationship between the two.
yeah,
of
and the
them.
fact that
Fair
I think Paul
enough.
earlier you made a point that it did appear that
There was a
elements of
political-
the exactly.
Uh-huh.
So
Let me address
she was
that
trying
one.
to say
See,
that
made a-
Daniel Ofori is known to the lady, and Daniel Ofori could not have been pushed by the NDC to do so. They are the checkered history.
But
in the
that
past.
may be the reason why Daniel Ofori's application should have been rejected, because it is clear that you and this woman have a fight, and you are trying to take advantage of a certain situation.
Even though
that's the reason why.
even though he may state other points which may be
Yeah, but they had
salient.
3 applications before them. So before you examine Daniel Ofori's petition, I would have thought that once you know that there's almost like a personal situation, you do not allow constitutional provisions that are created for all and for longevity, that somebody can use his personal dislike for somebody, apply through a constitutional provision. It has to be very carefully looked at.
So that one
Because
failed.
I grant
The
you-
personal one failed.
No, the point is that Daniel Ofori, that's the point that Honorable Beatrice is making, that Daniel Ofori and Gertrude Torkonoo are perennially at loggerheads.
No.
If the two of
they are
them
the
have
checkered
been at
history.
loggerheads, if they've been at loggerheads in the judicial system, and it's well known that these people are loggerheads, then Daniel Ofori should be precluded from being able to
Even
apply
though
through-
he may raise salient points.
That is why I'm saying that because it is law, it is a living organism. So we will grant a 10% chance that when a person who has a personal
And the
matter with
probative value
another,
placed on that should have been lower.
it should have been much, much lower, because this is a person who we all know. I didn't know, but I'm finding out from those who know that indeed she and Gertrude Torkonoo have been at each other's throat, including making an application to the Supreme Court for Gertrude Torkonoo to recuse herself. And the Supreme Court granted it. Not perhaps because they felt that Torkonoo was biased, but they also looked at the history from High Court, and they may have found that, well, it's okay. And Madame was agreed with it, and she stepped aside. So the fact that Daniel Ofori is the one raising this issue should give us a bit
Paul,
of,
are you
know,
saying that if I'm a loggerhead with you and you do something that is wrong,
that's what I'm
I
granting
can't-
10%
yes.
to. But we all know
So-
how
so-
human beings are. So we all know how human beings are. So we all may like to take advantage of power one way or the other. That is why the limitations of power is very, very important. That is why when the Constitution gives a power authority to
that
anyone,
the issue about
they
the
also
GM,
give
etc., raised by
limitations.
Daniel Ofori should not have been treated with a lot
Of seriousness,
even
because
though
Daniel Ofori
it's a
may have
breach.
a personal interest. Now, whether it's a breach or not, and we are now hearing that during the hearing, witnesses came to testify who all said that this has been happening every now and then. Well, the fact that something has been happening every now and then doesn't mean it's correct. But is it the reason why you remove a Chief Justice? That there's been some sort of breach in her travel policy, or even if she hasn't breached it, that some money that is being looked for around her travel policy, obviously no intention to steal has been found, and that is why we remove a Chief Justice. If that's how we want to do it.
Paul,
let's
look at it this way. The Chief Justice in the Abronye case, for example, when the matter of paying salaries and some facilities and giving some privileges to the first ladies, etc., came up, she was quite categorical about it, that Article 71 cannot be expanded to include persons who have not been named. So salaries could include privileges, other facilities. Now, she's quoting from the terms of conditions of service to say that a condition of service granted this. Meanwhile, she has also said, or knows very well, that the conditions of service could not be placed above, for example, the Constitution, which she has interpreted to say that could not be expanded to include the spouses of the people. How do you reconcile
her
that?
conditions of service does not include her spouse benefiting from her travel.
Yes.
It does.
You know what I'm saying?
Is that what she's been accused of?
Yes, but she has said, so benefit for her travels, who pays for the travels, the per diem, etc. These constitute privileges, or you can even say facilities, that will come with the office.
Yeah.
So if she's saying that even the president's wife and vice president's wife, etc., cannot be entitled to those facilities and privileges by extension, why should she?
But
they
Make her spouse-
don't have any appointment.
yes, but that's the point I make.
don't
Are
have any
they in the
appointment.
president's
She has
condition of
an appointment.
service? In the president's condition of service, are we supposed to be paying her wife? If it's part of the condition of service, or are you
but
alleging,
no,
are you
I'm-
alleging
I'm-
a conflict between conditions of service and the provisions of the
Exactly
Constitution?
the point. Because she has interpreted that,
that when that
to mean
conflict
that you
occurs.
cannot expand
Okay, so
the
here's a case
ambit
where
of Article
her
71.
conditions of service grants it, but we are discovering that those provisions and the conditions of service run contrary to Article 70 and 71 of
Exactly,
the
which she
Constitution.
has interpreted.
And then she had occasion to interpret at the Supreme Court, where she said that when this conflict occurs, the Constitution should reign supreme. Is that the point she made at
Yes.
the Supreme Court? That when there's this conflict between.
That's what she said.
Okay, so that these conditions of service.
It's not that categorical.
Hold on.
wait,
She was very categorical.
So if that is so, it means that these conditions of service that all chief justices have benefited from, But we are now finding out. We are finding out that it runs counter to Article 71 provisions. Then we are saying that you Torkonoo yourself, you know that already. So when you saw the conditions of service, you should have raised that point and changed the conditions of service so that they will conform to Article 71 and 70 of the Constitution. That's what we're expecting of her, isn't it? That she should have done that. Okay. And for the fact that she didn't do that and that she traveled and she, as it were, through the conditions of service, breached the 1992 Constitution, that is why we are removing her. That's what we're saying, isn't it? Okay.
And the committee said that constituted an assault on the public purse.
Yeah.
Who said that?
The committee.
Oh, the committee said this constitutes an assault on the public. But you agree with that, don't you? Okay, fair enough. And if that's how we want to remove a chief justice appointed under the 1992 Constitution, that's okay.
No, you see, Paul, the challenge is that until she gave that decision, there was this unspoken rule about...
Was it a unanimous decision of the Supreme Court?
It was.
And she was one of the unanimous.
She authored the opinion.
She wrote the lead opinion.
Yes.
Okay,
No,
so
she wrote the unanimous opinion.
yeah, so who were the others on the unanimous? Those who agreed.
I've forgotten.
That's even more interesting. So if it was a unanimous decision,
Yes,
who were the others on the panel?
So let me get them
because
for you.
that means they all agreed with her.
Yeah, so Poorman was there. So Justice
Poorman was there.
So
That's very interesting.
Yeah, so
this is Justice Poorman.
Agree with you. Poorman's argument is that we cannot make laws together where you say this and then you say that, oh, well, I will not apply the laws I have made to myself. As for me, I'm exempted.
So let me give you the other members of the panel.
And Poorman also has the same conditions of service, doesn't he?
No,
he's not a chief justice. He's not a chief justice.
But the justices of the Supreme Court have very similar conditions.
No, but he's not a chief justice.
But he's not a chief
and we don't know.
How do you know whether...
No, we don't know whether he has used it. We don't know.
That's very
even
important.
if he has used it,
So
that's
let me give you the rest of them.
dangerous.
So Lovelace Johnson was there.
Does that negate her appointment?
Does this
No, let me say, Professor Asid was there and Guy was
assuming
there.
that this court case didn't happen and that we have no record of a Supreme Court decision in which Torkonoo participated where she has said these things, would it have changed something?
I don't know what the committee would have said.
We can't tell.
Because
I
that's
don't know
what
what
you are
the
relying
No, we
on.
can't
That there's a
tell.
contradiction because she herself...
Paul, let me help
But
you.
that's what the committee has said.
That what?
That's
I get that, but
that's the reasoning of the committee.
That's the point I'm making.
Paul,
So
let me
the committee
assist
relied
you.
on it. They heavily relied on Torkonoo's history in Supreme Court decisions, especially this case. So I'm asking that, assuming that case was not there, will they have had something to rely on, or they would have treated all chief justices as the same? And in finding out this decision anyway, are we asking the former chief justices to sort of pay the money back? Is that
No.
part of the conversation?
No.
Paul,
She hasn't been said.
can I make one suggestion?
You've been on for a while. I'll come back to you.
Okay.
Andrew, welcome. You've been listening quite intensely. Yes, your general thoughts, the three grounds. We'll come to former CJ Sofa Akufu, but many of the view that the grounds are not hefty or weighty enough to warrant the dismissal or the removal of a chief justice. And so I've said, no, it could be small, but once it's a breach of the law, and you are the chief justice, the one supposed to be the vanguard of a lot of these things, you could not have been seen going against or breaching any of these. What are your general thoughts?
Well, so let me wish your lovely viewers a good morning. Let me apologize for coming late. I was engaging on GTV. Let me wish my learned friend a good morning. Paul, good morning. First time meeting you. My accountant himself, a good morning. Well, so my view on whether or not the breaches are enough or weighty enough to lead to the removal of the Chief Justice, for me, reflects on our tolerance level for misconduct. I think this week in the UK, Deputy Prime Minister has resigned for some disparities in the payment of his stamp duty. So he attempted to pay the stamp duty. I think, except that he paid something much lower than
expected.
And yet because of that, he has been removed from office. Well, if it was in Ghana, we'll be saying that, oh, just a stamp duty. You understand? So for me, I think the issue of whether the weight doesn't come in at all, it shouldn't come in. It shouldn't come in at all. My honest views about this is the weakness of Article 146. That's for me. I think that's the biggest issue. I think, in my opinion, that should have been the center of or it should have captured the.
I think that will come second.
But yeah,
So
but in terms of whether or not what constituted misconduct, whether or not they were wicked enough. My personal view is that it shouldn't matter. It shouldn't matter. And the CJSF said that you can do whatever propaganda you want, you can make all the noise you want. The law is the law. As the law stands today, the CJ did some 3 things that she was not supposed to do. In the opinion of the committee, that constitutes stated misconduct, for which reason she should be removed. And for me, I can't make any legal argument against that. When I was coming, I had my own accountant and very good friend.
I'm surprised. You think that the Chief Justice should be removed because, for example, she transferred a member of the judicial service. You think that is okay?
Is it a misconduct?
I mean, really?
No. The question is it a misconduct?
How is that misconduct? It is a committee that came to that conclusion. How is that a misconduct?
Listen.
What was the basis for removal? So they made that decision. They came to the conclusion about transferring.
Listen. I think the issue is the 3 grounds for which she is being removed are the misconducts. So if we are making an argument.
Who decides if they are misconduct?
The committee, per Article 146, where what's called a prima facie case has been made, then a committee ought to be set up. It's the duty of the committee to decide whether or not the grounds for which we've passed, whether or not they constitute a prima facie case, whether or not enough evidence has been adduced to determine whether or not indeed she breached those misconduct. You understand? As to the weight, as to the threshold, there's nothing in the Constitution, and we don't have anything by way of precedence to determine. And that's why I'm saying that for me, the biggest issue is one of review of Article 146. Also, I think an argument that suggests that the removal is premised on just politics is one that you struggle to justify. One, now the removal is based on the petition of Daniel Ofori. Now, if you know the person of Daniel Ofori, then you are going to struggle to prove that indeed he was influenced by His Excellency John Mahama and his government.
Not exactly, but the ground was fertile for it. So the point is, he might have taken advantage of the fertile ground to do so.
You see, he is a petitioner. Now, all the arguments that has been asked to the weight to place or not, I would have agreed if he was the adjudicator, if he was in the position of a judge. But I don't know of any law that says that the weight to be placed on a petition should be determined by whether or not the petitioner is at loggerheads with the accused. You understand? If the Ofori was the judge, then that argument can stand. But for a petitioner who is making an allegation, because for instance, at the time when he makes his petitions, they are allegations. And that's why we set up some people to determine those allegations, to make a determination as to whether or not it constitutes any truth. So, in terms of weight, you can't place any weight, or as I'm saying, I'm struggling to find any law, any basis for why you place weight on a petition based on the relationship between the petitioner and, for want of a better word, the accused. You see, for me, I think that is on trial as principle. I think that is on trial as principle. I think I said this here when my contact was here some time past. Because what would be your moral justification if you did not have the cojones to speak against the application of Article 146 in the case of Derry, in the case of Charlotte Osei, and suddenly you think that you want to have issues with the application of the same Article 146. So the two biggest things.
But I think the 146 in this particular one involves the Chief Justice.
But the principles are the same. The only difference is that in this case, because of the potential of breaching the principle of natural justice. They are saying that when it comes to the determination of prima facie case, and then is the president must. But in terms of the principles, they are essentially the same. The human beings may change, but the principle is the same. So as the people, we've sat down and we've allowed this very weak Article 146 that, if I want to also speculate, can be weaponized. Is it the case that when it was being applied against Charlotte Osei, it was used as a weapon? What did we say when the former president, His Excellency Nana Akufo-Addo, said that I'm just a conveyor belt? Is John Mahama not just a conveyor belt? And I can't believe
the context not different, because in the case of Charlotte Osei, the prima facie determination was made by the Chief Justice and the recommendations given to him. And so that he just had to carry it through. But in the case of the Chief Justice, he was involved in the determination of the prima facie, if that was not even done by him.
No, but in terms of the principle, it's the same, because where is the president? The Constitution is saying that where the committee has made a decision, you are bound by that decision.
I mean, the determination of the prima facie.
You see, but even so in terms of the principle, it's the same. It shouldn't matter who determines that. At the end of the day, that's why there's always a committee.
Yes, I'm saying that the issue about the conveyor belt,
it's the same.
Could be different, because the president was involved in the prima facie determination.
Not sufficiently,
which is key.
Is it not sufficiently enough for you to make an accusation that is the president who's using his politics or is witch hunting the CJ? Because at the prima facie case, you look on the face of the allegation.
Yeah, so you could look at some allegations on the face of it and you say, no, there's nothing in this. Yes. We don't have much in this to ground the prima facie.
Exactly.
I can look at it and say, no, we have enough to ground the prima facie. It depends on who is dealing with it.
But at the end of the...
So, for example, similar allegations were made. Former President Akufo-Addo thought that there was nothing in there, and so he dismissed it.
Yeah.
But similar allegations made, the issues about the nomination, proposed nominations, etc., were made by Professor Azar. But Nana, the president, felt that there was nothing in there, and so he dismissed them. So I'm saying that
could have made an argument. Would I have been right, and would I be standing on firm footing if I'd said that, based on the perceived association of the judge and the president, like my brother is saying, that's the reason why, in his opinion, he didn't see any prima facie.
But the point really I'm making is the distinction.
Yes,
between
and that's what I'm saying. It's not weighty enough to support a suggestion that the president is witch hunting. Yes, and that's why the person making the petition is important.
It's important.
You understand? And for me, if there's anything beyond the principle, the clear lack of principle, if there's anything that for me is showing here, once again, you see, we can't have this discussion without looking at the review, because I have an issue with the opaque nature of the process. I think I said that the last time. It's so opaque that it gives room for speculation. But the law is the law, unfortunately. You understand? And we've had chances at questioning Article 146 when it was being used against Derry, when it was being used against Charlotte Osei. You understand? So for me, beyond everything else, you see, principle is on trial here. And so it's sad that I have to mention the MPP members. But the manner in which we've politicized this process, the manner in which we've turned this into another MPP NDC battle, and the position both sides took when it was being applied to Charlotte Osei, betrays our fidelity to principle, to the extent that my brother John can sit on set and be questioning the political affiliations of judges. Nobody is neutral. You see, even the CJ is neutral. But for this system to run, for this system to run, it is in our interest that we do not know where some people, where the allegiance of some people lie in terms of our partisan politics. And that's why our focus ought to be on the principle. And what's the principle here? As the law stands now, if there's because we've not defined what constitutes stated misconduct, because as there's no definition of what constitutes stated. If there's one, maybe I can be educated. Then there'll be no basis for you to question whether or not where there's a proof that indeed there was a misconduct. That because of the weight or lack of...
So that's even a bigger problem. That once you want the person out, no matter what somebody brings, it could have been that, okay, no, maybe she didn't wear her wig well. And by not putting her on her wig well, you could say that's stated misconduct. Even though it could be bizarre.
And that's why for me, I feel that the biggest discussion ought to be the review. Because the review is so weak. The review is so weak that it can, it's so easy to remove the CJ. But that shouldn't be the case.
I see.
You understand?
You agree that we have to deal with the provision rather than the persons involved?
Well, I mean, okay, so first of all, the point must be made that on the side of the NPP, contrary to what my friend is saying, our defense is for the judiciary, not the individual, Madam Torkonoo, except that she's a person involved here. We feel that by this act of the executive, the judiciary has been weakened, and that doesn't augur well for our country. So don't say that NPP and NDC are taking different positions regarding this, as if NPP is defending Justice Torkonoo per se. NPP is defending the judiciary because we believe that what has happened is an assault, on the judiciary. So on that basis, I believe that something ought to be done to protect the judiciary. And so why not? I agree that 146 should not remain as it is. If you look at the removal processes of the two heads of these other organs of state, it's quite laborious, and to leave that of the Chief Justice in this simple manner, for me, is a big problem. And so I will support any attempt to amend this provision, and I think that the Constitutional Review Committee should look at it very carefully, so that our Chief Justices are protected in such a way that you cannot just be removed on the whims and caprices of your adversaries. For instance, there should be no reason why a Chief Justice should be removed because the person transferred a member of the institution in which she is the head.
We don't know the full story. I don't. But the point is
but this is what the presidency has given us.
What I'm saying is, the transfer
could
be anything. Okay, did you transfer me properly?
No.
You understand? If you didn't transfer me properly, and how you transferred me was arbitrarily done, and it was tainted with malice, hate, etc., then that's a problem. If you transferred me in accord with due process, that's fine. You understand? In fact, in some instances, we even heard that he transferred the gentleman to a lower position or something. I'm not so sure about that, but I think I heard that somewhere. So they had the full complement of everything. But they called witnesses, etc. So the point I'm trying to make is that the transfer in itself may not be the problem, but how it was done.
No, but what we've been told is that she transferred the gentleman contrary to Article 296.
Yes.
So
the discretion.
No, discretionary powers given to her as administrative head of the institution. She uses that to transfer somebody, and you say, no, you are wrong. On the basis of this, you should be removed.
But I know the discretionary powers are to be exercised within a certain limit.
My brother, you see, there are various levels of, in my view, punishment. And so some acts, even if they are wrong, should be looked at carefully. That a transfer should ground a remover, a transfer of a member of the institution which she has should ground a remover. But we are in this country, haven't we seen even dismissals by the appointees of the government? Outright dismissals without even giving them hearings. Have we asked any of them to be sacked? And so when we want to apply this, let's be careful, because look, I can tell you, I know state institutions that have dismissed several people. In fact, some of them have come to me, and they were not even given hearing. What is their reason? Because they were appointed by the NPP administration. And so when we have to amend the law, from the question you asked, I believe that we need to amend it and make the removal processes, I shouldn't say difficult, but we should ensure that anything that warrants a removal is something that, is big enough, not something as trivial as it. And that is why I, in my view, think that this is just political. Because look, imagine that this particular CJ, and my brother, let's all be careful. And I'm saying that let's not pretend as if all is well. Imagine that this CJ was appointed by, let's say, Prof. Mills, okay? And he saw the person saw the CJ, and President Mahama received this form of application. How would they have treated it? And so the woman's crime is that she was appointed under the NPP administration. Let's face it, if we want to protect the judiciary, let's ensure that it is done well. How can a Chief Justice be removed because she made a recommendation to the president that we need to increase the number of Supreme Court judges? In any case, did that happen? It did not even happen. The appointment didn't go on. And look, you have the situation where people make genuine mistakes. And you see, when you read the I think it's the reasoning, the letter, the notice of removal, they are saying that Chief Justice shouldn't have made that mistake. And the point is that Chief Justice, in her position of Chief Justice, should have known that this is not a process. And even though it's not grounded in the Constitution, it's provided for under the Ghana Bar Association case. And so, for making that decision to recommend to the president, that amounts to stated misbehavior. How do you use this as a basis for removal of a Chief Justice, a head of institution? So clearly, this was just politics at play.
I see. Let me take a few of your messages that have come through. Christian from Sandema says, good morning, everyone. I'm finding it difficult to understand Madam Beatrice. Is she telling us that if a person is not happy with a judgment against you, so you can petition for the removal of that judge? In fact, the removal of the CJ is political. Madam Beatrice and the NDC government cannot convince any Ghanaian that this is not political. The President and the Speaker of Parliament have been traveling up and down with their families, using our resources for nothing. This one from Astro, from Suhung Jato says, please, I want to ask the Swami MP that the process used to remove EC, I think you mean Charlotte say, does it contradict the law? If it contradicts the law, give us difference of removal of Torkonoo and Charlotte say, no, not Jin Mins and Charlotte say. So this one from Hamza from Pig Farm says, good morning, my brother. My brother, we were told by functionaries of the NPP that we should allow state institutions to work, and for that matter, the removal of Madam Charlotte say should not be drawn to the doorsteps of President Akufo-Addo. So the question here is that why are we trying to put the blame on President Mahama when the removal of Madam Torkonoo has gone through due process? President Mahama only acted based on the recommendation presented to him by the 5-member committee, period. You say. This other one from Prince Henry in Koforia says, the NDC, okay, no, I'm not discussing. Okay, on the issue of the former Chief Justice Torkonoo, the NDC and the President have no hands in removing the CJ. Rather, the President acted based on what the Constitution requires him to do, because if the President had failed to act, he, the President, would have been facing impeachment by now. The MPP, as it stands now, has lost touch with Ghanaians and must not dream of winning political power soon. In the name MPP is not, if the name MPP is not changed to a different name. This one says that Asiedu never said the CJ must go. That's Asiedu Nketia. He dared them to produce a video. Yes, he said the EC chair must go, but never said the CJ must go. Does his submission mean that the decision by Nanado not to remove her was also political? Okay, in respect of the earlier petition filed by Professor Azar. Let's look at that letter that removed the lady Chief Justice from office, just so because we've been speaking about it in many respects. Page 1 of that, and it's a restricted letter which has found its way into the public domain. 1.9 says that in the opinion of the committee, the travel expenses which the Chief Justice heaped on the judicial service when she traveled on holidays in September 2023, first to Tanzania with her husband and second to the United States of America with her daughter, together with the payment of per diem to the spouse and daughter of the Chief Justice, constitute unlawful expenditure of public funds. It cannot be justified in law or policy. And it says those acts constitute avoidable and reckless dissipation of public funds, and in the view of the committee, to have been occasioned by the overall head of the judiciary and the judicial service, whose duty it is to guard public resources allocated by the government, is caught within the spectrum of stated misbehavior. It goes ahead to state the second one. The committee states without fear or favor that the Chief Justice unjustifiably breached the provisions of Article 296A and B of the Constitution 1992 in the way and manner that she transferred Mr. Baden. Her conduct amounted to misbehavior. Another one. The committee is of the view that the conduct of the respondent falls squarely in the category of misconduct described as stated misbehavior under Article 1461 of the Constitution. Goes ahead to say the committee is of the opinion that the action and conduct of the Chief Justice falls within the meaning and categories of stated misbehavior as provided under 1461 of the Constitution. However, the Chief Justice, qua Chief Justice, so that's another point. The Chief Justice, qua Chief Justice, cannot lay claim to ignorance of the nomination process and procedure, notwithstanding the fact that the process and procedure are not spelled out in the Constitution but case law. The appointment of CJ herself as Justice of the Supreme Court went through the very process and procedure set out in the Ghana Bar Association case. Therefore, to seek wittingly to outwit this known process and procedure for appointing Supreme Court justices amounts to misbehavior in the eyes of the committee, and the committee finds it as such. So that's just for the record of the letter. That's yes.
I think you can answer it. I think you can answer the question.
Okay, so
if you see the ruling of the committee,
yes.
Hardly do they refer to any witness, as we will normally see.
No. This is not a. This is a letter.
There's a letter they
wrote. So the presidency took various portions.
They brought up the witnesses and dismissed because of course the witnesses testified for the madam.
Yeah, they
evaluated. There's an evaluation of what the witnesses said.
The 10,000 pages.
But that's the one that cannot be made public, right?
Yes.
It cannot be.
But Beatrice has seen it, right?
No, I haven't.
If she sees it, it's still not public.
It's not public. So this is they just took salient points from it and then formed this letter with it, because obviously
it would have been interesting for us to see.
But I'm talking to have the 10,000 page report.
No, so what the committee said is that the documents, evidence, the record of proceedings is about 10,000 pages, which they reviewed before coming to the conclusion they came to.
Then the committee reviewed.
When did they submit to the presidency?
They submitted a report.
Okay.
And in that report are the findings. So they say that, so if you look at the letter from the secretary to the president, points 1.9, we rely on, so there is a full report, and this is just the conclusion of their report.
But why didn't they finish all the three before they brought report one? Is that how it works, though?
Because and I'll answer that question, but it's important I use my time.
Okay.
So that
all right, so I'm interested in that. So that's the point. There were three.
Yes.
There were three petitioners.
I'll answer that question.
And of course, Franklin Kujo is joining us now. We'll
are you going to answer because the committee have explained, or you happen to know?
No, I'll answer that question.
So there were three petitions. So some of us were wondering that why the rush? Why don't you finish with the three so you put everything together? Why deal with it this way? Or is it a case that because you found enough merit to remove her in the case of the first one, so let's just go ahead.
But IPO said the timetable was ongoing. They were expecting to go back to the committee 2 days later, and then they had that report.
So what's the issue really? If you know?
I wouldn't know why, but as a lawyer, I should think that if on the first one the committee has found the merit, then it means that subsequently the other petitions will be moot. Especially when the committee would not have the powers to issue consequential orders in respect of all the petitions, so that they will not say, okay, on the basis of petition 1, we make these orders, on the basis of petition 2. So if they found merit in the first petition, and you can even glean from the petition and the committee's trajectory that they were not interested in the petitions or the grounds which were personalized. And if you look at the second and last petition, they were a bit personal about some of the things that the petitioners had suffered. You know, so these the Daniel Ofori one was a mixture of a number of grounds, and they found merit in the 3. I think he had about 28 or so.
Yeah, but
grounds.
they told the Torkonoo's team that they were ongoing. They knew that it was ongoing. That's what Ayikwe to
so
said.
my information also is that they had given parties the time to file written submission, and after written submission, nothing again. And so I don't know whether they failed to file their written submission. But written submissions are...
No, but he said they were expecting...
No, finish everything.
in
respect of the other cases.
The petition.
Which are the other two?
The other two.
All the petitions.
So they had considered all the
written submissions in respect of all the petitions.
No, let's get it clear. Written submission in respect of Daniel Ofori, and did Daniel Ofori write the written submission?
Yeah,
and do we know that the other two were also heard? The other two petitions, were they heard?
Yes, they called their witnesses and everything.
Oh, I see. So
So
Daniel
what we
Ofori...
need to know is what the CJ said, whether it's true or not, that Daniel Ofori and the petitioners were not allowed to come to testify before her so she can cross-examine them.
Can you answer that?
Can you answer that? That's what she said in her press conference.
That's what she said in her press conference. And I remember the argument has been that she, as a judge, she knows that a petitioner can opt not to testify. In fact, she granted Madam Jane Benson that as a petitioner, a plaintiff, or whoever, I can decide not to testify if I am of the opinion that I can't call other witnesses or I have documentary evidence sufficient to prove my case. And in the case of Daniel Ofori, the committee indicated that they presented about 13 witnesses. And then Madam Torkonoo presented 12 witnesses. So although he did not testify as a petitioner...
No, she said the witnesses, Torkonoo said the witnesses, so-called, were subpoenaed by the committee and their staff of judicial services. And that they were subpoenaed by the committee.
They had a number of...
It's not so much Daniel Ofori lining up.
Torkonoo subpoenaed a number of witnesses herself.
Yes, but
in
she
fact,
had witnesses
she subpoenaed the secretary to the president to even come and testify. And indeed, he appeared by counsel, and the committee said, we do not think that your presence was needed. So as of who subpoenas a witness or otherwise, in every proceeding, it is very normal. They can do, I can look at the strategy, but the point has to be made that there is an invitation for President Mahama to act as though he were a class prefect of the judiciary. President Mahama cannot exercise supervisory jurisdiction or some class prefect role over the judiciary, so that where we are being told that a misconduct has occurred, then they say that, oh, they could have been given a lesser punishment. Who will be doing that punishment? In the case of the judiciary, if it was the executive, somebody could have gone to court for a declaration, somebody could have gone to court for something. But in the case of a chief justice, where a breach occurs, however trivial people think the breach is, I want a lawyer to tell me what would be the remedy of a citizen in the case of the judiciary, and especially in the Chief Justice case. President Mahama is not a headmaster of the judiciary, where he will come to the determination that there is a misconduct. And so although there is this misconduct, we think the money involved is just about $50,000. So let me do this. The Constitution does not clothe him with the powers to do that. So he cannot do anything about it. The point also has to be made that in all these discussions, it is very evident that President Mahama has not done anything wrong. The NDC, the government did not have a hand in this. If the committee had come out with the conclusion and said that we do not think that the allegations contained in the petition is weighty enough to remove the Chief Justice, the law in Article 146(10) says that President Mahama is bound by that finding. In the same vein, where the committee finds as a matter of fact and law that the Chief Justice ought to be removed, President Mahama is also bound.
So, which is really agree that the president could actually orchestrate this for a certain desired outcome.
How would he have orchestrated
in the constitution of the committee, 2 Supreme Court judges, he will choose, I mean, two of them there. The 3 others, they could be anybody. Once they are not lawyers or council of state members, etc. You know, they could use anybody and have this outcome. Will you agree with that? And so that would tie in with the weakness of 146.
Yeah, I would agree with that, but we must first situate it in context. The first context is that you had 5-member panel. 2 were Supreme Court judges. 1 judge, Justice Asiedu, who I've appeared before a number of times, a very strict judge for that matter, was appointed by the NPP from the High Court, Commercial Court 1, to the Court of Appeal, and then to the Supreme Court. If we were to make the partisan argument, then we ought to have been reading the dissenting opinion of Justice Asiedu if the NPP claims that he was a member of the NPP, for which reason they promoted him. But this was a unanimous decision. In fact, the point also has to be made that in the course of the proceeding, the Chief Justice herself, both as head of the judiciary, went to the Apex Court together, and her colleague said, we do not find merit. She again went to the High Court. Her case was dismissed. So what really do people expect government to do, or the president should do? I want any lawyer to assist me and say that if I were the lawyer or counsel to the president, I would give the president a contrary advice to what the Constitution says, or that there are some jurisprudential ways we think we could have done this, or there are some best practices we think that this ought to have been done. I want a lawyer, and I challenge the NPP lawyers to assist me and say that we think that, well, on the basis of so and so decision, the president could have done this. I think that the point has to be made. The President Mahama did no wrong. I agree that if we have to have discussion about reforms, for instance, if we need to codify what stated misbehavior means so that it's not subject to different interpretation. But then again, as we speak today, in honor of the Constitution that has served us for over 30 years, that has guided us, somebody ought to be telling me and convincing all Ghanaians that something wrong was done. Then we can be having a discussion. But as we speak, the president did nothing, absolutely nothing wrong. And so the point also has to be made that in all these, President Mahama afforded the Chief Justice every courtesy that could be afforded. For instance, at the Premier Fashi case, the argument has been that there was no requirement that she should even have been given copies of the petition, because Nanado did not even give her copies of the petition at the time. President Mahama says, you asked for 7 days. I would give you 10 days. How courteous can the president be more than this?
Very well. Great. Let me talk to Franklin. Franklin, welcome to the program. I mean, a lot of legal discussion here, but from a policy viewpoint and civil society viewpoint as well, how are you guys taking the removal of the CJ? And in your views, do you think that there was something untoward in the process? It could be on the face of it, or behind the scenes about the removal.
So if you can hear me, good morning once again.
Good morning.
Good morning to my good friends in the studio. Paul, good to see you. Well, look, I think you gauge the society's response to decisions like this by several means. I mean, go onto the social media and read comments. I mean, just listen to radio and then just ask yourself, what are people really saying? I'll tell you what I think, by the way. And if you don't get a groundswell of, should I call it negative comments, as in very opposed to this, to the act, then it means it must have gone down well. So I think that's the first thing I want to say. And I think for me, I've not seen, and I'm a social media avatar, if you like, and I've seen quite a lot of conversations. I look at certain people's wall, and I saw conversations that goes on there. People are like, oh, well, okay, well, somehow she brought it upon herself. Others say she played a hand too much into the Nanado regime, as in basically doing the bidding of Nanado almost every time. And then also others also say, well, she didn't respect, the Ghanaian thing, right? So there were so many other contemplations about her time in office. I think the last straw, I think what has made many people, and again, the larger society, virtually nonchalant, probably not concerned, is the way she acted during the last moments of the last administration. You recall those cases against the speaker and the way and manner she went about it, or the almost near banter in court with the lawyers. It didn't speak well at all. And I think many people took offense from that angle. I mean, I sat back during that time and asked myself, wow, if because remember what led to that incident, right? I think the people of one of the constituencies like this were supposed to be denied because
the vacation of the 4 MPs, I think.
yeah, exactly, the vacation of the 4 MPs, which incidentally was stated by political action. But then people started asking questions. In fact, I was an ardent supporter. I've been an ardent supporter of Justice Torkonoo, by the way. I mean, I worked with her when she was the supervising High Court judge on commercial courts. I was the only civil society guy there. She tasked me to do a number of things, and I saw her efficiency. But when that case broke, when that case came up, and the vehemence with which it was being defended, and I sat back and asked myself, so the people of Sal were just treated like fleas, you know. So I started questioning certain actions, and I got really worried. But anyway, that has come and passed. I'm just telling you what sentiments people express. Now on to what I think. Well, look, for me, the fact of the matter, for me, the only one thing that appears to be the differentiating factor, aside all the arguments that have been made, right, against her, is the issue of the audit. You see, this thing, let's not kid ourselves. Look, we are in a country where procurement is the big gig, is the biggest economy in this part of our world. Why do you think governments come and change previous projects that other governments have actually started? I mean, you think the NDC will continue the agenda 111? Let's not kid ourselves. Even if they continue, they have to finish, prioritize, sell their projects before they continue those ones. How the agenda 111 was even procured is even a problem, right? We don't even know the full enchilada in terms of the cost and all of that. So who wants to continue something like that? Knowing very well that we'll be adding the 10% and not 20%. Nobody will continue. So let's not kid ourselves that procurement has to be the biggest bane of our economy. Look at all the things that have sent people to jail. If it is not related to money, maybe something, well, some other probably misdemeanor, whatever it is. But as always, and I ask myself, see, how else are we going to solve this issue? We've done proof math, what they call give me. In fact, the only thing we've not tried is BOFRUT. You know, the acronym we've not tried is BOFRUT. And I'm waiting, I'm sure very soon somebody will come up with a new financial system to with the acronym BOFRUT, right? We've done all of these things. Even now, my good friend Ato has come in, we want to tighten the fiscal rules, and we are helping him. You saw we did a program with international partners in the UK, and we are guiding the government. In fact, we are likely to secure some seed money to guide them for the next 6 months. But I asked myself, we want to do all of this stuff. Let some politician wake up and get some 10% somewhere, and they go scot-free, right? So why am I going round and round in circles? I'm coming back to this procurement thing that ultimately caught the Chief Justice. And you see, and so we've been having all the, every night and then you go, sometimes you fight. Look, even the EC, we are fighting with EC, Astra, for all kinds of procurement. You could see clearly that she fight with lawyers and all of that. It's just annoying. We analyzed over 1,000 procurement contracts between 2008 and 2020. 95% of them did not pass muster. But if you look at the sums involved, my brother, huge sums. So now that you are a Chief Justice, in fact, if a judge sits on a case involving anybody at all, whether layperson, politician, or whatever, and you are brought before a judge, and you are sentenced on the fact that you actually stole money or some appropriation, are the rules not there? You'll be jailed. Is that not what happened to you? So now that I listened to all the arguments and I found out that, oh, okay, so they relied also on the fact that she actually got herself an impress, which she was not supposed to spend. The argument that, she should have been guided by an officer, like a finance officer, and so she didn't know, it's neither here nor there. Please, let's disassociate politics out of this at all. Because when I hear such this, it gets me really angry. She knew, and she's at the head of the judiciary, she knows the laws pertaining to the issues around spending money. Look, in other countries, she would have been in jail by now. There are countries, was it Chile or wherever, that they found the president was wearing a wristwatch, I think a Rolex wristwatch, about $64,000. Police officers went to her house right? She was president too. They went to her house, found out what she did jail there one time. Let's not joke with these things. So for me, when now the conversation has become the fact, I mean, the conversation has come to the head, and people are saying, oh, but the money involved is not is small, it's 300-something thousand cities. Well, the fact of the matter is that the act that is being pursued, and not necessarily probably the sums involved. Did she know? Did she know that she needed to do that or not do that? So for me, that's where I get my worry really from. So you have this incident where you knew very well that you're not supposed to do what you did financially, and then you did. So let's nobody talk about political witch hunting. People may have said all sorts of things, but look, from a very pristine heart, and again, for someone who has been running this thing for 21 years, and I've seen almost every corruption-related item related to procurement, my brother, this is the clearest case, probably the clearest sign yet that we are doing something about procurement. And by the way, what it means is that going forward, we should be seeing the courts being more active. If you listen to the things happening at the Public Accounts Committee, sometimes I shudder and I laugh. Well, if you've been caught there, you have to be processed for court. The problem is that, you see, if the Chief Justice had been probably a private person, I don't know, probably a politician, maybe she could have fought this through the courts for a very long time, and then 8 years will come, and then people will forget about the case, which is another matter we need to talk about, by the way, because those who commit some of these crimes have deep pockets, they can fight you through the courts and what have you. So for me, look, on the singular issue, forget about the other things. I mean, the fact that whether she smiles or she doesn't smile, I don't care. Whether she said the law is the law, I really don't care. Whether she said, in fact, the other issues about elevating judges on her own volition, I mean, that's another thing. There's a gray area. Anybody can argue it out. That's one of the things people say she's also committed. I don't care. But I'm just looking back and asking myself, politicians have prided themselves as procurement champions. My own good friend Anado, until he gave me a haircut and then did all of that stuff. Look, he was a procurement champion. Don't forget, he brought the Minister of Procurement, right? He even had these procurement prizes being awarded here and there. But then when we look closely, his subordinates were not doing him any good.
Very well.
Right? So for me, that's the only thing I want to make. And I think that we should refrain from it being, I don't think it's, maybe there's some element of politics there, but frankly speaking, from where I sit, just
we don't see a lot of politics in there. That's fine. Great. So let me come to let me come to Paul. Paul, people like Sophia Kufu have not been happy about the decision, etc., etc. But deal with me, in your view, how do you think we should proceed? I mean, she loses her spot on the Supreme Court together with the CJ position. In your view, should that be how we should see all of this, or you think that she loses that should still be on the bench as a Supreme Court judge?
Well, it will be awkward for anyone who has been Chief Justice go through a disciplinary process, and then the result is that you are no longer Chief Justice, but you remain a member of the Supreme Court. I think that would be awkward. But also, the views on this matter will be valued and weighed, and who has a better view than one, and who was in the committee or who was not in the committee. I think that for Justice Sophia Kufu, the fact that she was she's been part of the process since the Council of State, and the fact that she herself had opportunity to participate in an Article 146 process, not as the accused person, but as one of the lead when the petition against Charlotte Osei was referred to her by the President in accordance with the law. She probably has a better view and a better appreciation of what has happened from her time at the Supreme Court into being a member of the Council of State. That deliberated on the prima facie decision. And apparently it came to a vote that she abstained from the vote. So she may have begun making her impression at the Council of State level. And then she appears before the committee testifying for Justice Torkonoo, the person in the box. And she engages with the committee, questions and answers are asked. So if she comes out of all that process and says that, as far as she is concerned, Justice Torkonoo was not treated fairly, I think that anyone who is observing the thing will give that a lot of weight. And so perhaps we have to wait to see what happens and and waits to see how posterity will hold it.
But would you have expected anything different from her? She testified for the lady. So obviously she believed in the lady's case. And so you don't expect her ordinarily to come out and say, no, she was treated fairly and indeed she failed the test. She went to testify for her. She was CJ before. Maybe a lot of the things she's been accused of today, she might have done same. I don't know. But because she came to testify for her, the probability of Sophia Akuffo saying that she was treated fairly would have been very low, given the outcome.
So the point I'm actually making is that she had indicated her position against the petition earlier.
But she only abstained. She could have voted against.
Yes, she abstained. But then she has also participated in Article 146 situation. And then she comes to the Council of States and 146 comes and says, I'm not interested in this one. So she's already taken a position. But the fact that she also went to the committee and must have engaged with the committee and testified with the committee gives her more information. So if she comes out to say that, looking at everything, and it would have been contradictory if, for instance, she had voted for it and comes out and says that the thing was unfair and all of that. But you could see her consistent position throughout the matter. I'm just saying that because of her intermingling with the process, her opinion should be given value better than, say, somebody like me who has only heard the Chief Justice's press conference and seen what she said and heard some of the things she said. I have not spoken to any of the lawyers who appeared. I've just listened to Ayikwe Otu. But Sophia Akuffo will have a better opinion on the matter. And all of the people, the chairman of the committee, Gabriel Palmer, was her colleague. And there are Supreme Court judges who are around. She may have spoken to them. So where she sits, she has much better information than most of us.
If you were to advise or to talk to HK Prempeh on what should happen to 146, what would that be? You said you made some presentations to the committee before?
That's the old committee. I'm yet to have applied, but I don't know what's happening to that.
What would be your view or your suggestion?
It's an entrenched provision, actually. It's an entrenched provision.
Yes, but we don't know what form it's going to take. Perhaps a referendum could come up. We don't know.
Yes.
So what if you were to speak to them on 146? You have any suggestions to make?
Yes. The suggestion to make is that you just have to know that it's not a provision that we should tinker with. If you permit me, let's look at Article 69. This is the provision for the removal of the President of Ghana. It says a president shall be removed from office if he is found in accordance with the provisions of this article, A, to have acted in willful violation of the oath of the allegiance and the presidential oath set out in second schedule, blah, blah, blah. B, and that's the important one, to have conducted himself in a manner which, A, brings or is likely to bring the high office of president into disrepute, ridicule, or contempt, and B, to have conducted himself in a manner prejudicial or inimical to the economy or the security of the state, and C, incapable. That the president has done something or taken a decision that is inimical to the economy of the state. You can find that with many presidents. But we never go there. Of course, the Article 69 provision includes Parliament, and therefore there's a heavy political leaning on it.
So you don't go there at all because it may not
succeed. Can be protected if he has majority in Parliament.
In 95,
yes.
in 95D.
The CJ's. Should I go on?
Yeah, go ahead.
Yes, the CJ's process is not submitted to politics at all, because the framers of the Constitution did not intend for politics to have anything to do with the removal of the seat. That's why in the case of the president, they said that you can remove the president on these grounds. The grounds seem very likely to achieve economic e-levy. That's it. He has acted or taken a decision that has brought the economy inimical to the economy. E-levy, Mr. President, let's go. But then they know that there's a political buffer, so it's up to the political party and what they do. In the case of the Speaker, the same. But in the case of the Chief Justice, they could have said, after all, the Chief Justice appears before Parliament. So they could have said that after you have done your prima facie, let Parliament take it.
Parliament should have a view on it.
Parliament should have a view on it. But they decided that the political forums of the three arms of government are the executive and the legislature. These are political forums. The judiciary is not and ought never to be political, especially in our situation where we don't vote for judges. It ought never to be political. So we try to insulate it from all the politics, because at the end of the day, it's the judiciary that will be the catalyst to the sustenance of the democracy. And I've written a book about Ghana's politics, and I come to the conclusion that the Fourth Republic has been sustained by the courts. Without the courts, this Fourth Republic would have gone away. If the court, and I highlight the important decisions that were made, if the court didn't make the decisions that they made in all of the cases today we wouldn't be where we are. So the court is something that we will agree with and disagree with. There may be judges who may think right and judges who may think left. That's allowed.
So given all we have seen,
Yes,
you
but
think
we
it's
shouldn't
about
touch
time
that.
we brought in the political part of it? For example, Parliament. That will make the removal a bit more difficult.
No, I don't
We
think
should
we
just
should
leave
do
it like
that.
that?
We should leave it like that and recognize that Article 146 for the removal of the Chief Justice is something that we do it once in 100 years.
We can't tighten it because the discussion we hear around is that now the term of a Chief Justice will be coterminous with that of a government.
That shouldn't be.
Yes, but that shouldn't
we must
be.
resist that temptation as much
but
as
it
we
may
can.
happen.
Oh,
And
it
how do
shouldn't
we-
happen.
how do
I really
we-
hope that it shouldn't happen. I mean, we've had the issues about who's going to be the next Chief Justice. You probably are going to have Justice Bafoboni who will leave next year. You probably will have Poaman. You have Amadou Tanko. Eventually, you might have Yoni Kulendi. I don't see why there should be a situation where it's even part of the conversation that, oh, when we come, we will. No. The issues of Justice Torkonoo, I hope one day we will come to the decision where she'll be heavily compensated by the Republic of Ghana. Maybe not now, maybe later, maybe much later. But I'm believing that as we operate the Constitution, we will come to a situation where one day there will be a clarion call for Justice Torkonoo to be compensated. That's what I'm hoping. But Article 146, I think we should leave it, but do it once in 100 years.
And what do you think? 146, what can we do about it?
Well, I
Should we
think
leave it the way it is?
No, it has to be reviewed.
How will you review that?
So, in fact, I agree with Paul to the extent that the politicians shouldn't, this shouldn't trigger an issue of create a situation where the.
No, but see, we've had a political actor speak.
Yeah.
You know, we've had a political actor speak.
In fact, that makes me believe that in the unlikely event that the NPP comes into power sometime, this process will be triggered. Indeed, up until when Charlotte Osei was removed, we never had any cause to believe that there could be a reason to think that Article 146 was being weaponized. But right now we know that it can't be weaponized. Too, we are here having this serious debate on what weight should trigger the removal of the. But you have a situation where Article 146 in what constitutes a misconduct is so open. Because
you initially made the point of stated behavior. I mean, my friend Ken Kumsin says the Supreme Court in adjudging with Attorney General interpreted stated misbehavior broadly to include corruption, abuse of office, bias, and other conduct that undermine public confidence in the judiciary. I mean,
I'll go as far as to say that what constitutes stated misconduct should be codified. It should be clear. Because you see, the focus of this constitution is to guarantee the rule of law. We shouldn't create a system where people have a discretion as to when a stated misconduct would be enough to remove the CJ. Another issue I have with Article 146 is the opaque nature. The clause that says that it should be held in camera. In my opinion, I think it's as serious as flying against the principles that underpins our
because the point they make is that, I mean, it's to protect the judiciary. But the other question to you quickly is, people have said this decision weakens the judiciary. Others who have said no, it is judicial accountability. So it's actually good for the system. Where do you stand?
Oh, I stand on the accountability.
So this doesn't weaken the judiciary?
No,
it will not make judges afraid to take certain decisions.
It shouldn't, and that's why some of us are calling for reforms. You understand? Because I think that as the Article 146 stands now, yes, if there's any doubt that it can be weaponized, I'm not saying that Mahama Dems have weaponized it, but based on how it was used in 146, in 2018, against Charlotte Osei, because it's not just the justice.
So in the case of Charlotte Osei, you think it was weaponized, but in this case, you don't think
I don't have any evidence to suggest, but there is a strong belief that it was weaponized, as there is a strong belief to one was also weaponized. The fact that I don't agree with those who are holding that view does not mean that there's a view. But you see, you want a system where it will be very difficult for people to think that the application of what's called provisions of the Constitution in line with the principles of probity and accountability. That's also one of the principles that underpins our Constitution is being weaponized. If the people, the sovereign, hold that view, then yes, then that belief that this amounts to an attack on the judiciary can be justified. And that's why some of us think that, listen, the essence of making this as transparent as possible is to give it some form of legitimacy. Because you can't say that on one side, on one hand, you are holding the judiciary accountable. But the committee members, the people who took those decisions, are essentially not accountable. As the people who decided that Justice Torkonoo has conducted herself in a manner that ought to cause her to be removed, are not accountable to the people. You understand? And all we are saying is that let's frame the Armed Forces in a manner that will be in line with all the principles that underpins our constitution. The principle of the rule of law, the principle of accountability, and the principle that says that they are using the powers granted them under the constitution to our benefit. You understand? So I believe firmly, I'm on the position of reform. And the portion that, in my view, needs reform is what constitutes system. It should be clear too. It shouldn't be opaque.
Any view on 146 reforms, etc.?
Yeah, I mean, I believe that we need to reform. I strongly believe that we need to be able to protect that sacred institution. I agree with Paul. I don't think that we should ever have a cause to invoke 146 again in this country. I mean, unless it is so grave that all of us, will sing, from one hymn book that, a removal should happen. It is not something that we should take lightly to remove the head of an institution. So I'm surprised that some of our people, especially our friend Franklin, who joined as vice, believe that, well, he mentioned 300,000 CDI. So let's say there is some, I don't even want to call it misappropriation, some 300,000 issue. We say that no, it should also grant a removal. Look, I was reviewing our constitution. I was just going through, and if you look at Article 68, which talks about the absence of the president, right? That whenever the president is out of the country or before he leaves, the vice president should, be sworn in. The president of the republic recently left the country when the vice president was not in the country, when the speaker of parliament was not in the country. He knowingly left the country, knowing that our constitution expects at any point in time that either he himself, his vice, or the speaker of parliament will be in the country. He knew that, but he left the country. He's been emboldened to the extent that he feels that he can violate the constitution and go scot-free. Nobody spoke about that. Constitutional violation like this, we think is normal. But when somebody uses the administrative authority to transfer somebody, it is okay to use that as a basis to remove the speaker. So you see, we are not being honest. We are not being truthful. It's like, when it's against this person, then even the transfer, yes, she didn't conduct herself well, so she ought to go. But when it's about constitutional violation of the president who has sworn an oath to protect the constitution, leaves the country, knowingly violate the constitution, we don't do anything about it, we don't talk about it, everything is okay. So this country, we are just deceiving ourselves. Hopefully, 146, even if it's not reviewed, my belief is that no chief justice should be allowed to go through.
I've heard some of your colleagues say that if they come, they will do the same thing.
Well, I have had conversation with some of them, and
that's like a popular view.
Yes, we disagree on that, and I think that it is okay to disagree on these issues. I don't believe, personally, that we should take that stand. I think that as a party, we should look at continuing, building our institutions. You understand? And so we shouldn't make it a point that when we come to power, we remove any CJ, even if the person hasn't done anything. So if we have to come to that conclusion, it has to be a decision taken as a result of maybe some serious, violation of the constitution. So it's not blanket that once we come, we take the next chief justice, and it shouldn't be the case that when we come, chief justice will never be removed unless we see some clear violations that every Ghanaian will accept that no, for this reason, the CJ must go. I don't think that we should, if you have these kinds of allegations, we should never entertain a removal of Chief Justice based on these kinds of allegations.
Do you have any particular pick or preference for who becomes the next Chief Justice? Quite a lot of them, the distinguished people.
I dare not say it.
Bafoboni, Amadou Tanko,
who
Justice Dennis,
who am I to even suggest?
No, but you're an MP, you're a lawyer for the minority. I mean, just a view.
No, that's a presidential.
Paul, you have a view on that, who should be? I saw your analysis, though. But I mean,
everyone may have a view, but the ultimate decision is for the president.
Do you have a view, Andrew?
They should just maintain.
Bafoboni.
Yeah.
Is that possible? Is that likely? I mean, or you don't know?
I thought you asked me the same question. You're asking a different.
All right, I want to take a break. So let me read a few messages. Good morning. I think the Swami MP and Paul are just speaking with emotions. I mean, they've done some analysis, though. They have not quoted any part of the Constitution the committee breached. The law is a law. Greetings to Beatrice Annan. This is from Bukari Ibrahim. This one, Suleiman Bamba in Ashaman says, the removal of the Chief Justice is just simply the law at work. People are in jail and due to her judgment, so she can't be more human than any of them. This one from Ajoy in Accra says, hello, good morning. If I have to go by what Beatrice is saying, can I conclude that those who have been elevated to the Supreme Court, including the Chief Justice by this administration, are NDC persons? She says one of the panel justices was put there by Nenado and is therefore an MPP person. Good morning, Salam. Kofi Menu in DC says, John Darkun says the MPP is defending the judiciary and not the ousted CJ. Why then are they attacking the president and not the constitutional provision? The president had no choice than to act on it. This matter about the president having no choice. Yeah. Please tell Madam Beatrice to give us the conditions of service for the CJ. Also, ask her, does the constitution allow head of departments on government agencies, parliament, etc., to transfer subordinates? This one says, President Mahama did no wrong. Every judge should be sacked when he crosses a traffic light. Congratulations to Mahama. Good morning. I'm Rafiu from Golu. It's sad our judiciary is going through what it is going through. It's a witch hunt and political. Joe Baba in Bogatanga says, in fact, if care is not taken, our democracy will really sink to the gutters. Former presidents were petitioned to remove certain chief justices, but due to the fear of damage to our democracy, they turned down those petitions. The chief justice is the head of a full arm of government and must not be compared to the chair of the Electoral Commission. Christian from Sandama says, good morning, everyone. I'm finding it difficult to understand Madam Beatrice. She's telling us that if a person is not happy with any judgment against you, you can petition for a removal, that the judge, in fact, removal CJ is political. But and NDC government cannot convince any Ghanaian that this is not political. The president and the Speaker of Parliament have been traveling up and down with their families. Okay, I thought I read that earlier. All right, so we'll take a short break. When we return, we'll use the rest of the time to deal with this land matter. The president is lifted a ban on the sale of state lands. What really does that mean? We'll do that when we come back. This is a big issue. Don't go away. Yeah, welcome back. This is a big issue, the final lap of the program, and a few messages again. This one from Chris in Ashalebutu says, hello, it's surprising to hear those who sat down, kept mute, and watched wrongs committed against certain individuals have become the holy advocates of the rule of law, who woke them up from the pretentious slumber. The former CJ should pay for her own crimes. Chris sent in that from Ashalebutu. To the next topic, I mean, the lifting of the temporary ban on the state, on state and public land transactions. The president has lifted a temporary ban on state and public land transactions, reopening access for the sale, lease, and processing of state lands under new measures designed to ensure transparency and accountability. The ban, which took effect on January 10, 2025, was introduced to allow for a comprehensive review of Ghana's land administration system. Speaking at the inauguration of the newly constituted board of the Lands Commission on Tuesday, the president said the pause exposed major shortcomings that demanded urgent reforms.
Area of our national life is in greater need of a reset than our land administration system. Our ancestors taught us that land is sacred. However, successive years of mismanagement, compounded by political interference and institutional decay, have left our land governance system broken and vulnerable. Independent anti-corruption surveys have consistently ranked the Lands Commission amongst the most distrusted institutions in our country. Public lands meant for the benefit of all Ghanaians have been illegally sold, rezoned, or encroached upon with little accountability or consequences. Ladies and gentlemen, the unrestrained dissipation of state lands is not the work of the ordinary Ghanaian citizen. It is spearheaded by influential individuals who wield public office not as a trust, but as a personal entitlement. Prime government lands, ecological buffer zones, school land reserves, forest enclaves, Ramsar sites, and even lately lagoons have been appropriated by individuals who have been given the responsibility of protecting them. This must end with this commission. In pursuit of this reform agenda, my government placed a temporary ban on all state land transactions to enable a thorough review of existing processes. That exercise has yielded valuable insights into the weaknesses of our current system and the urgent reforms that are required. So today, with the inauguration of the new commission and the adoption of robust accountability measures, I'm pleased to announce that the ban on land transactions has been lifted. Henceforth.
All right, so that's President John Mahama making an announcement there on lifting the ban on the sale of state lands, state and public lands. Let me start with Beatrice. So of course, sale of public and state lands became a big issue prior to the election, where people were accused of buying prime lands with just a pittance. What has the president seen? What work has been done? Why is the president lifting the ban now? Can we now go and acquire any land we want? Or does it mean that we can do so, but at a higher, maybe price? Or what exactly is the case?
Yeah, thank you very much. I think that the impression has been created that by this announcement, public officials or all persons have the right to just acquire for themselves what we describe as state or public lands. And that is not so. Let me put on record that it is not a waiver for people to acquire for themselves lands, whether vested or public. If you recall, indeed, you stated rightly that the acquisition, and in some cases, in very arbitrary manner, in which in the past government allotted lands to themselves, became an issue in the 2024 campaign. And during the transitional period, government was seized, or the incoming government was seized with a lot of credible information and reports that members of the MPP were rushing to regularize lands which have been acquired unlawfully. If you recall, at the time, we also had the oral committee practically trying to gather data and information for subsequent use. So on 10 January 2025, the Secretary to the President wrote to the Executive Secretary indicating that all transactions relating to public lands should be halted. And all transactions included the regularization of leases, searches, and a number of things, practically all transactions. And so along the line, the Office of the President was actually inundated with a lot of requests by even private people who say that because of the nature of the transaction, they could not conduct any business, including searches. And so on 19th March, there was a partial waiver that was given to say that the directive issued on the 10th of January did not include processing of lands which were acquired prior to 2017 and also searches. Now that would include 1957 as well. So just to give you the scope. Now, at the time these were happening, there was an interim committee that was put in place to analyze and also present a report to the government on what should be the new processes to curb all these abuses that we had in the past. The committee presented its interim report. And let me also say that after the interim report that was presented and the measures taken to curb the arbitrary grabbing of lands, then this announcement by the president came. But it's also important to say that because this was a speech of the president, the details were not contained in the speech. But to the authorities which are concerned, they know that it is not just a blanket application where, like you are indicating, can anybody just go ahead and just acquire the land. What the lift covers is that renewal of leases. Some people acquired leases as far back as 1957, some people long. So where it has to do with renewal of those leases, the Lands Commission is at liberty to proceed. Where it has to do with processing of second transactions, let's say that assignment, mortgages, and SAP leases, the Lands Commission is also at liberty to proceed with those things. Where it has to do with regularization of leases outside regional capitals, because in the report, we are also finding out that those who are so interested in grabbing public lands are not interested in lands which are not in regional capitals or prime areas. So they don't want a land in somewhere, in some corner somewhere. They don't want it, you know. But that does not even mean that those lands outside the regional capitals could be dealt with anyhow. Again, when it has to do with the private or what we call the PPP transactions, now we are saying that when it comes to the regional capitals like Accra, Kumasi, and all, you know that some areas are registrable and some areas are not registrable. So especially for registrable areas which falls under the ambit of the Lands Commission, in regional capitals, there are exemptions which are applicable. But the most important point that I want to make is that this demonstrates the commitment of this government to deal with our land tenure system in a way that does not benefit the political class. Because sometimes if you look at how people boldly say that I have a house in Cantonment and I bought that land for 200,000 cedis, which can't even buy a land somewhere in some village somewhere. It's a problem. So it demonstrates that President Mahama is actually listening. The issue about state lands, vested lands, where lands will be acquired and not given back to the allodial title. And then
so we were saying that if, so with the lifting of this ban and all of that you've spoken about, if someone now wants to acquire or buy state or public lands, it will be sold to the person at the going market rate?
What we are saying that transactions which are permissible under law, the Lands Commission can undertake. But it's also important to situate this context in the promise of the NDC in our manifesto, that public officials or people who are related to politically exposed persons would not be permitted to acquire public lands. And so even with this caveat, you realize that there is a manifesto promise that we need to...
But that's quite a tall order. You have to find out whether they are related to...
We should be able to know. Because I can tell you that there are some people who in the past, they are outright politicians. We know them. They acquired the land. It's not. This is not even a secret. The issue of political
so
class.
Now they can hide behind people and do it.
They shouldn't be able to hide behind people and do it. That is why when you are found out, you should be dealt with. And that is why. And let me conclude, Salam. And that is why we must not be having a discussion on quantum of misconduct. Because then when so when someone then acquires a land in, let's say, Eastern region, you say that, oh, it's Eastern region, so don't punish him like the one who acquires the land in Cantonment.
Very well.
You know, and for me, I think that we ought to support the government on this. I think that we should not, yes, a lot of wrongs have been done in the past, but going forward, a government is committed and saying that all politically exposed persons should not be seen as benefiting with their office, we ought to be supporting the government. And I would encourage the Lands Commission to do right by all manner of persons and not be under any influence to say that I'll do the wrong thing. And for me, it's a call in the right direction.
Franklin, yes. What do you make of this? If you are politically exposed, you have some piece of land you can afford. You can't go through the process genuinely to get it. I mean, talk to me generally about this new lifting of ban. It became a big matter prior to 2024 elections. How do you feel about this new regime in terms of land administration or state and public lands administration?
Well, let me start off by saying how disappointed I am as a student of land economy. As a land economist, we're supposed to be the ones more or less guarding against this avarice, the race to the bottom type of purchases that we see. Quite frankly, just annoying, right? I mean, somebody buys a property in the prime area for the value of chicken change. I mean, why do we do these things to ourselves? And I think some of my colleagues may have been part of it, but I didn't go ahead to practice the land economy fully. But as a land economist, as always, I'm a land economist, and I feel very sad that land could be optimized for good. And then we have allowed people who are not creating value, people who are not delivering value, just by dint of some political office, they acquire swaths of prime land. Those areas are meant for people who are creating value and returning value, employing people and all of that. Even this one, some of them even buy it cheap, right? So the whole society is just, and the Land Commission, anyway, I hope that they do things right. Look, once this was stayed, once the purchases were stayed by the president, maybe it was a good thing because, but you ask yourself, at the end of the day, you're also losing ground rent, right? I think the Lands Commission was losing a lot of ground rent. People are not paying. It was really a challenge getting people to pay in the first place. But now that, the purchases were stopped, somehow you also saw some laxity in that. I hope that with the lifting of the ban, we'll get back to basics and do things right. There should be under no circumstances should anybody be allowed to purchase prime property for cheap. And I think if a lands commissioner, whoever perpetrates and allows such things to happen, must also be punished. It's not just a politician who should be found out. I feel really, really angry sometimes when I hear the way we've managed. Look, you'll be surprised. Lands in Accra, only 10% of lands in the country are actually digitized. The whole country. It's only, and I think it's just Accra, right? Only 10% of lands in the country are digitized. What are we doing? Why are we doing these things? So land is the most important asset in the country. You've read Hernando de Soto, the Ministry of Capital. That's how countries build their wealth. Here we give lands to people who have no value, have not. Anyway, let me stop here.
Very well.
Land is such an emotional issue for me, but
great.
Right, thank you.
Yes, Paul. So yes, Beatrice has provided some context, beyond what we knew or what we heard from the presidency. Are you satisfied with the approach? Politically exposed persons more or less banned from acquiring prime lands. I don't know how that really will work, and all the processes that we understand will follow this. Are you impressed, or are you okay with the new regime when it comes to dealing with state and public lands?
I think that the transparency that we attach to this is what will solve the problem. Because as for politicians, they always say that they always know how to say the right things. So this is a policy that has come in place. I live in Teshi, maybe you live in Dansoman. You go about your daily life from January to December. You are not aware of the transactions that the Lands Commission has made. So I think that the commitment should go beyond the rhetoric and say that the Lands Commission will publish on this portal every week, every 2 weeks, all the land sales that it has done on certain Class A, Class B type of lands. And that is not available to everyone, but it's on a portal that journalists can access, lawyers can access, and other people can access. Until we have that kind of situation where we will know that this is what is happening. It's every government who can wrap a policy together and say, this is what I want to do about land. When Oral first started, they made a publication of some people to whom land had been allocated by the Akufo-Addo administration. That was the last we heard of it. Oral didn't continue to say that we are taking the land from them or we could take from them. It looked like they went on an embarrassing spree to embarrass some of these people and put their names out there. Names were put out there that these people have, by connotation, illegally acquired state property or something like that. In fact, the matter crawled into the appointment committee hearings. When the Honorable Idrisu Haruna appeared before the committee to be vetted as Minister for Education, Alexander Afenyo-Markin asked him, where do you live? And he says, I live in cantonments. And Afenyo-Markin said, okay, so it's okay for politicians to have a house in cantonments? I think he started by asking him, how many years have you been in Parliament? And then they sort of put out a profile. And then he asked him the question, where do you live? He says, I live in. I think this was the question asked in Akan. I remember. He said, Utihi. And Haruna said, cantonments, oh baby. And everybody was laughing. So I don't know why, if the land is available and is being sold for what is being sold for, and there is a politically exposed person who may have had an earlier life and had been successful at his career or his work, and he has that kind of money that he cannot apply for it. What is important is the transparency. It is what kind of politically exposed person is acquiring the land? What kind of person is doing X, Y, Z? That's really the transparency. If the transparency, that which is in the bosom of government, is not shared with the general public by any means, then these policies may not see the light of day, because you will find a policy will be done and then behind the scenes things will be happening. When the Galamsey fight started, people were saying that Akufo-Addo has broadly launched the Galamsey program, but it is his own people who are doing it, because the transparency is not there. You can't tell. You don't know what is happening. When the issues started coming out about who and who have received allocation to mine in the forest, it created a revelation and a big news story about important people who had received land allocation, people who were not even connected to any land business had received land allocation. It was clear that they may have received these things as a result of their political connection. So the transparency is the foundation for these policies to work for the whole.
Very well. Great. Andrew, Paul talks about transparency. Would that solve the problem?
Well, of course, because I think transparency in the form of disclosure is at the center of conflict of interest issues. But most of the laws against conflict of interest obligates the subject matter to disclose. So I think it's in fact it's critical in solving this issue. To add to what he's saying, I think also there must be a clear definition of who is is the focus on public officials or on politicians. So let's say you are in opposition. You are a politician. Are you a public officer? So I think there must be some definition, some clarity on who a politician or a politically exposed person is. And would you include...
But is it even fair to say that because someone is a politician, the person cannot acquire, some kind of land?
And that's what the policy, and I agree with you that it should be is a matter of transparency. I think the burden should be on the person to disclose. There must be full disclosures.
Your friend, Dr. Kwabena Dufo, some of his friends were rooting for him to be his son. Kwabena Dufo Jr., doctor, were rooting for him to be a deputy minister. And on the social media pages of his classmates, they were hoping that he'll be deputy minister of finance or something like that. And they were enjoying their thoughts. Now, assuming he had become Deputy Minister of Finance, this is where everyone knows who he is, his background. Should it be said that because he's Deputy Minister of Finance, when there's a land allocation that the Lands Commission is making and they are charging the right price, that he should not be able to participate in it? But it should be published so that we know that this politician, we think he can afford it. This politician, we are not sure about it. This one, and then it can generate a conversation. Without that, really, we can't tell where it's going.
You have the last word on this. I mean, a lot of the issues came when your party was in power. People getting lands left, right, center at, prices.
Yeah, I'm not sure people were getting land left, right, center.
That was the accusation.
Because I didn't get so...
That was the accusation. You didn't get.
Because I didn't get. Because I thought I was part of the...
creme de la creme. You thought you were part of the creme de la creme.
Definitely not the creme de la creme.
just kidding.
But it's just sad that, you know, Beatrice will sit here and say that members of the NPP rush to register lands acquired unlawfully. I mean, Beatrice, we cannot be doing that to our politics, right? You are in government now. Do you know that some NDC members are acquiring state lands now? You may not know, but it's happening.
How would you be acquiring state land?
Well, there was a ban, right?
Yes.
You say ban, but you see, people are doing the thing. People are doing things.
I'm telling you on authority.
People are doing things.
No, so people disregarded when disregarding the ban.
People are doing things.
Council, be fair to some of the comments you are making.
Let me make my point.
So the president will have to
I'm
sign.
really surprised.
And the list will be in the name of the president and the person. No, but we'll be able to that.
What he's talking about is that
You
have been settled.
So once the ban is
The thing has
lifted,
already been done.
It's all settled.
The thing has already been done. See, by not getting it, you know what is
not
going
about
on.
settling the deals. So
People are selling these.
once
anyway.
it's lifted, the president signs
Yeah, he
them
signs
and
it.
it's dated.
How-
Good to go.
But the Mahama government engaged in a lot of populism, and that is what I say. Look, we are talking about lands. Today, I was on the news. France 24, deadly land dispute in northern Ghana displaces nearly 50,000 people. 31 people dead. What is the government doing about it? This is the more serious matter you should be concerned about, not lands in
And
Accra.
I agree with you. And
No,
that's a sweeping statement you make as
listen.
well. I agree with you on that. Yes. I agree with you that that's a very serious
If you look
matter.
at what is happening in the north, the administration, I believe, is sleeping. Go on France 24, and this is international news all over the world. That now there is a lot of issues in land administration in this country. I believe that what is happening in Accra is just a tiny fraction of the issues all over the country. So if you want to settle land problems, Mr. President should look up north. Savannah region, people are displaced, people have left the country, people are in dire straits, and they need help.
Refugee camps.
Yeah.
And that is what I believe the
the
government.
Which is
police
very
giving
serious.
us an hourly briefing on this
you
matter.
know.
The police is not saying anything about it. This is as serious as anything.
And Mr. President is interested in the lands that will enrich some of his appointees. I am very worried that that is what he wants to spend his time on. Yeah, it's true. But what? He's interested in how you guys are going to now
raise a
share
very
state
valid
lands.
point.
You shouldn't.
You raise a very
You know when you were speaking, I never ensured
let
because I had
Exactly.
issues with the way you
just-
started by accusing NPP members
just go ahead.
of unlawfully acquiring state lands. I had a problem with that, but I didn't talk about it.
Just conclude.
You understand? So please, as a country, let's all be careful. I think that the politicians, all of us, should be careful when it comes to state assets. I mean, in terms of this land. For me, I think that this whole period the president put the ban on, it didn't amount to anything. They have laid the ground rules, they are sharing the lands already. The president should tell us how he's going to solve the problem in the north. That's also about land. And for me, that's more important than what's happening in Accra.
Very well. Thanks so much. That's John Darko, Council Minority Caucus. That's a big role, Council for the Minority.
Yes, I know.
Sorry,
And
if
MP
all
for-
the
and
MPs
for Swan.
are paying legal fees.
Another big seat.
You don't pay
There's
that.
no big seat. And I've got Paul Adewale, journalist, host of Good Evening Ghana, Andrew Appiah Akubi, Andrew Appiah Dankwa, spokesperson for the Movement for Change, also private legal practitioner, Franklin Kujo Imani, Africa president, and Beatrice Anamfiu Esquire, presidential staffer. My name is Selam Adonu. Thanks so much for being with us this afternoon. Catch you same time next week for another episode. Have a good afternoon.